Yes. Hello, my beautiful friends, and welcome back to Supreme Court Decision Day. We are waiting for some big cases to emerge from the hands of the Supreme Court. We are now learning at this very moment that there are 2 boxes, which means we may have a little bit of a lighter day. We had 3 boxes on Tuesday, and we had 5 decisions. So with 2 boxes, we may get 3 decisions, maybe less than that. But right now, we have the SCOTUS blog folks who are heading into the court right now. And we'll see what the first decision is from our SCOTUS. We've got some big cases that are yet to be decided. Of course, we're waiting for birthright citizenship. We'll see if we get that today. It was argued a little bit later in the Supreme Court session, so it may not be coming today, may be coming next week. And if we're only getting 3 decisions or so, we've got 12 decisions left, which means we've got a lot of work to do. We'll see how many ultimately come down today, but that means we may be back to, next week on Tuesday and perhaps even on Thursday in order to get through it all. But the cases that we're keeping tabs on, and as soon as they drop, we'll get into them and allow the court to reveal what all of the decisions are before we zoom in and unpack them together. We'll also drop the links in the chat. So if you're out there and you want to just get the full decision, we'll copy and paste the PDF to the full decision so that you can check that out. But we're waiting on some pretty big matters to be decided. Of course, birthright citizenship is a very big one, a generational, nation-changing type of decision. So we'll wait for that. But we've also got some executive power cases. And the first one just dropped. This is Monsanto versus Dernell. And this is an interesting one. It's coming out of Missouri. It's 7-2. It's by Brett Kavanaugh. And Monsanto, the question is about state preemption and whether federal laws will preempt state laws as they relate to insecticide, fungicide, rodenticide, and other matters. So the question is whether federal law, which is a federal statute, overrides state law. And whether the EPA, and not requiring warnings on things like Roundup, glyphosate as it relates to cancer, whether the state can sort of change those rules. So what if a state says you got to put all these warnings on the label? Federal law doesn't require it. Does federal law override state law? And it does, according to this decision. So we're waiting for the PDF to drop. Court holds, looks like 7-2. Very interesting decision. Ketanji in the dissent, and she's joined by Neil Gorsuch. So a little bit of a interesting pairing there. We've got obviously a very right-leaning Neil Gorsuch joining a very left-leaning Ketanji in the dissent. And so we're waiting for that PDF to drop, and then we'll see what else comes next. That may have been the least interesting case on the day, quite frankly, but we'll always zoom in on it. But there are many other decisions that are out there. So we've got, in addition to that, is that one's getting queued up right now. We've got some TPS cases, which are going to be very interesting. Whether we can actually terminate TPS status, temporary protected status, in immigration law. And so let me share with you the PDF in the chat if you want to grab it. Here's what we're looking at: Monsanto versus Dernell. So dropping that one for our friends if you're out there and you want to open it up and check it out. We'll take a look at this one. It's a 53-pager, and you can see the holding 7-2. We got Jackson in a dissent along with Gorsuch saying that federal law overrides state law. And if a state wants to impose additional requirements on disclosures, then they're not going to be able to do that because federal law already, and I think we'll probably see a lot of supremacy clause analysis here, overrides what the states want to do. Congress passed the rules. And so I would say that's probably a big win for Monsanto, which seemingly is a problematic company. So we've got that one queued up. Let's just take a look at some of the breakdown here. So it's a 53-pager. Judge Kavanaugh delivering the decision of the court. We'll come back on this, obviously, and we'll zoom in and we'll see exactly what's going on. But just wanted to see kind of what the breakdown is. So Thomas with a concurrence. Oh, did we skip that? Judge Thomas concurring. Clarence Thomas concurring in this. Sorry for all the scrolling. Yeah, there it is. So a concurring opinion by Clarence Thomas. Interesting. So a little bit of a separate rationale, reasoning for him. And then Gorsuch in the dissent. And that's going to be very curious to see how this whole thing breaks down. So 25 pages in the main holding. Clarence Thomas with a pretty short concurrence. And then the rest of this from about 30 to 53 is all going to be Jackson and Gorsuch dissenting. So, interesting one. We'll come back to that. Let's see what else we got. Ooh, Hawaii gun case. This is a good one. So, Justice Alito with a decision on this one. The Hawaii gun case is a victory. So, the court holding that the Hawaii law is unconstitutional. Let's go. This was Hawaii basically inverting the rule, saying you can't bring a gun onto a piece of property unless you get explicit permission from the owner to do that, and inverted the whole Second Amendment. Looks like this decision was written by Judge Alito, amazing judge. Roberts joined, Thomas, Gorsuch, Kavanaugh, Barrett. Barrett with a concurrence. Thomas and Gorsuch joining with Amy Coney Barrett. Kagan leading the dissent. Jackson and Sotomayor in the dissent. All right, so we're going to drop that decision too in the chat. So this looks like it's another 6-3 with some concurrence. So maybe some slightly different rationale. 76-page decision, which is a good one. Hawaii blown out. Shall not be infringed. So we'll come back to this one and we'll see what is happening here. So that's going to be very good. Hawaii unconstitutional. Stop infringing our Second Amendment rights. So another good one. And that was a big one. We were keeping our eye on that one. 10 cases left. As I mentioned, we've got TPS. We've got a question about foreign invaders, aka illegal aliens, coming to the border, and whether coming to the border qualifies them as arrived at or in the United States. We had a great set of oral arguments here where Amy Coney Barrett was saying, what does it actually mean to arrive in the United States? How do you distinguish that from arriving at the United States? If you're in the United States, maybe we treat you one way, but if you just come to the border and knock on the door, are you in the United States? And does that give you special immigration privileges? So we'll see if that one comes down. We've got some election cases we're waiting for. So if you see any of these pop up, we've got RNC versus the FEC about party expenditures and political caps. We know that money is essentially free speech. Ooh, talking about Al Ultralato. This is the one I was just explaining. So this is whether an asylum seeker, 6-3 on this one, outstanding. So that, yeah, I think is going to mean hopefully that he's not in the United States. 6-3. We'll see how it breaks down. But Amy Howe, she's in the courtroom. She's the one who's getting us all these decisions and all these updates very quickly, saying the case challenges the federal government's policy of systematically turning away, quote, asylum seekers before they reach the border. The Ninth Circuit held that non-citizens who were turned away before they could enter had already arrived in the United States. Ridiculous. For the purposes of federal immigration law. Okay, so before they're in the United States, they were holding in the Ninth Circuit out of California and the West Coasters that they were in the United States. They clearly were not in the United States. And so Mullen versus Otralato looks like another 6-3 decision. Alito with the lead up on it. Let's see how the breakdown is. Alito with Roberts, with Thomas, with Gorsuch, Kavanaugh, Barrett, Thomas in a concurrence as well. And 6-3, Sotomayor, Kagan, and Jackson dissenting, saying, well, if you stop them before they get in, then I guess they're still in. So here's that decision dropped in the chat as well. So another good victory there. And let's see if we get anything else. We may be getting close to being done. Sotomayor is now reading from her dissent. This is racism. These are just people who want to come and have a better life, blah, blah, blah. We'll see what she says. But we've got two, I would say for sure, are victories. The other one, is a kind of more of a technical case about federal supremacy and state law. Jackson, Kagan, Sotomayor, all dissenting, all writing separate dissents, probably very upset about it. And so let's see what the breakdown is here in terms of pages. This is a 70-page decision. Alito, sometimes he can be very verbose, sometimes and very thorough. Other times he's just pretty quick and to the point. This one looks like there's a lot to it. And he goes for about, not too long, 22 pages. So we'll hit that one. Thomas concurring in a short, maybe 4 or 5 page concurrence. And then page 30 to page 70 are the leftist dissents. All right. So very upset about everything on a ranting screed from Sotomayor, who is very upset that they're being turned away. You just come to the United States and you're basically in. Hi, I'd like to come into your country. Oh, okay, great. Come on in is really their standard. So we'll hit the highlights on the dissent on this one, but another big decision. Let's see if we've got anything else. Sonia Sotomayor's second read from the bench this term. Ahmad, who's there, says she really lost her patience with her colleagues. Okay. Oh, interesting. So Clarence Thomas on this one also talking about class-wide injunctive relief, saying, yes, thank you, Clarence Thomas. Stop issuing nationwide, class-wide injunctions from lower-level district judges who think that they can just govern the entire country. And so we'll, of course, zoom into that. We always like some good Clarence Thomas concurrences and majorities. Sotomayor dissent is 35 pages, almost twice as long as Alito's majority. She big mad this morning. So, of course, just a bunch of, maybe it could be a blog post over on MS Now. So, yeah, we'll see if Congress changes any of that, but why would they change it? It's the right rule. You don't get to just come in, arrive to or at the United States and be considered in the United States for immigration purposes. So far, pretty good, I would say. We got 2 big wins. And the longer the dissents from Sotomayor and Ketanji and Kagan, the better. That means they're just more mad. So we'll wait to see if we get anything else. We know we had 2 boxes. We might be wrapping up. I'm sure Sotomayor is in the courtroom right now, just kind of screaming and shouting and doing her thing. But we'll zoom in on all of these. It is a beautiful morning. So the other cases that we're waiting on are, okay, somebody says we might be getting another opinion. Alito has 3 opinions, and I think we've only seen him with 2 today. So we might be getting another case. Let's see. Monsanto, who decided this one? Kavanaugh. Yeah, so we might be getting another decision from Alito. We love ourselves some Alito decisions. He's delivered some very good ones. So he got that one in the Hawaii gun case. And Alito also had this one in the border case. So we might be getting another one. And Amy Howe inside the courtroom says that Sotomayor is still reading from her dissent. Still going on. Whining and whining about it. So we've got guns, we've got border, and we've got Monsanto. And this was 7-2 with an interesting dissent joinder between Jackson and Gorsuch about getting poisoned by chemicals. So we'll come back to that. But we're still waiting. It's a beautiful morning. Someone tell Sotomayor to pick up the pace. Can we put her on 2x speed, please? Just with the remote. Hit her with the remote. Fast forward, fast forward, fast forward. So, yeah, the other big ones that we're waiting on, as we mentioned. So we got the border. There's also a TPS case. It's called Mullen versus Doe. See if that one drops. Then we've got RNC. So we've got some election stuff on caps on expenditures and whether that is an infringement on free speech. If money is speech and you can use your speech in elections, if you cap the amount of money that you can use, then is that an infringement on your free speech rights? So we've got that. We've also got the Chatry case, which is about a geofence warrant, so a criminal case, tracks the location data. Whether geofence warrants that are broad gobbling up of data, whether that's an infringement on the Fourth Amendment. That should be a very interesting case. Is that an illegal search and seizure? What are the standards for that? And Amy's saying, yeah, so we had the 3 boxes today. Did we have 3 or was it 2? I forget. I just forgot. I think 2 boxes is what they said, right? But she says they are also reasonably thick opinions, so which would take up a fair amount of space in the boxes, which is what they're actually looking at. They bring these boxes out like, okay, what do we got? How many boxes contain all of this? Yeah, so today was 2 boxes. So anyways, we've got a Fourth Amendment case that we're waiting on. We've got Watson versus the RNC, which is election day deadlines. Can you continue to count ballots after the election day is over? It's an Alabama case coming up from the Court of Appeals in the Fifth Circuit. And they added in a 5-day extra collection period for some reason. We also have trans sports cases. West Virginia versus BPJ. And Amy Howe is headed back into the courtroom for the remaining case. Presumably there will be one. So we've got one out of West Virginia. We've got one out of Idaho, Little versus Hecox. And one of them, Little versus Hecox, is whether or not state laws that bar trans women and girls from participating on female sports, whether that's an equal protection clause violation. All people, entitled to equal protection of the law. If a male wants to transition into a female and play on women's sports, is that a violation of the EPC? Because a woman can play on the team, why can't a man who says he's a woman? So we're waiting for that. Then the other one was about Title IX, so invoking some federal law as well. Basically the same arguments there. So we'll see if those are dropped today. Then we got some big executive power cases. Trump versus Slaughter, that's the FTC woman. Trump fired the FTC commissioner. And I think these are also very important cases because the Congress kind of creates these independent agencies, which are illegal, in my opinion. We'll see what the Supreme Court says. But we've got 3 branches of government. These independent agencies kind of exist in this like murky area between the two. Congress can impose some rules on what can be done with the agency, how people get appointed, how people get fired, what their terms are. But the executive branch actually governs and actually executes the law. So they also kind of live under the executive branch, but the president really can't fire people because Congress said so. So is it a congressional body or is it an executive body? What is it? So hopefully we learn more about that. That's Trump versus Slaughter. Then we have the other one, which is about the Federal Reserve, which is Lisa Cook, the alleged mortgage fraudster, who Trump said, you're fired, and she's not going anywhere. Same thing with them. Federal Reserve is a little different because there's more historical tradition in a governmental bank, right? In governmental finances that have been set up in American history. And so I think they'll analogize to those. So it'd be interesting if we see a split. And for whatever reason, they really like to protect the Federal Reserve. They don't actually rule a lot on the Federal Reserve, but it's this body that is not in any of the branches. It's definitely not under control of the executive branch. You can appoint people, but you can't fire them. And they control monetary policy for the entire country. Unelected. No accountability at all. You just shove them in there and they control really as much as any other branch of government does. They control our money and our monetary policy. Congress controls the fiscal policy, but the monetary policy goes over to them. And we all have to suffer based on their decisions. And they say to us, oh, we need the Federal Reserve because it's going to protect us against recessions and boom and bust cycles. And it's going to prevent inflation. And our dollar is going to be all well and good forever. And they don't do that. They're terrible. How many recessions, how many booms and busts, how many bubbles have we had with the Federal Reserve at the helm? So, you can make the argument that if you eliminated the Federal Reserve and you made it a little bit more accountable to the people, it might be a disaster. You might have a president come in and say, we're cutting the interest rates to zero, period. And then you might get massive inflation. You might get a bunch of economic growth or whatever, but then you would have the people who could decide the fate. It would be a part of our conversation. We wouldn't be delegating this key part of our sovereignty and self-governance to some unelected body that kind of does whatever they want without really any transparency at all. Even in the Supreme Court, we get oral arguments. You get the Federal Reserve meetings every now and then. They come out and they say things, but most of this stuff is happening behind closed doors. So we're still waiting. And apparently Sotomayor is just on a bender this morning, just going off and off and off. So we'll see if we get another decision and then we'll actually get into it. Let's see who's joining us. What a beautiful day it is. Just on, great to see you. Shane Sows is in the house. What's up, biology? We got Zone Girl, J-Ma, good to see you. Quell's joining us. G-Men in the house. Yeah, G-Men says, check out Thomas's concurrence on the marijuana gun case from 1 to 2 weeks ago. We read it, G-Men. Yeah, we had another decision day analysis here, and we read through that one. Ooh, and another immigration case. This is about temporary protected status. Mullen versus Doe. So this is whether or not Trump can ultimately cancel TPS status. Looks like it's another 6-3 case. Kagan dissents, Sotomayor and Jackson dissents. So it's going to be a great holding. So let's take a look at this one. We'll see if we get any more. Again, I'll drop the link from this one. So it's looking good today. I mean, very, very solid decisions today. We've got 4 total that have now been released. And let me consolidate some of these actual opinions, and then I'll just drop them all together. So we've got Monsanto here. So I'll put all the links into one little block quote. Wolford is the Hawaii gun case. And then we've got Otralato, which is the TPS case. I'm sorry, which is the border entry case. And let me see what I did with that one. Right here. So we've got some good stuff to get to. All right. And I've got 4 of these puppies queued up. Let me see if anything else is dropping. Court holds in this one that the Syrian and Haitian nationals are not entitled to orders postponing the terminations during litigation. Woo! Incredible. Big victory on this one. Yeah, that's a big victory. And what had happened here, if you remember, we were covering a lot of this. The TPS statutes, temporary protected status laws, are pretty clear that it's temporary and Homeland can, on their own volition and own determination, cancel them if they see to it. And that's exactly what Kristi Noem did. She came in, she said, yeah, I've reviewed all of it. You're not entitled to status in perpetuity. It's temporary. You're all canceled. Then the lower court said you can't do that and issued a stay on the order. The Supreme Court just came down today. Looks like another 6-3 decision. Not too long, but in the statute, it bars judicial review. Okay. Judges cannot substitute their judgment for Homeland Security's judgment. It's in the law. And hack judges have been doing this all over the place. So Alito with another decision. That means we got 3 Judge Alito decisions today. It's like Christmas. Thomas with a concurrence on that. Kagan, Sotomayor, and Jackson joining in as well. So another big one. So I think we'll start with that one. We'll do the border stuff. Then we'll come back. We'll do gun, and then we'll do Monsanto at the end. Big decision. Another 6-3. It's temporary for a reason. So no more de facto amnesty for people here temporarily. Just amazing. All right. So Mullen versus Doe is TPS. So here, let me share these. We've got 4 decisions. We'll see if we got anything else. Big ones. We got some very, very big, good ones today. And, you know, we may be let down on a couple of these other cases, in particular Birthright, but this is the type of stuff that is just critical. This is, oh, I can't paste them all. Bummer. All right. So sorry, YouTube friends. I'll split those up. It's too long. Links are too long. But anyways, point is, we have a very good court on many of these issues. And so we don't want to get too black-pilled out here if, you know, another one doesn't go our way. These are big, very, very big. And they're now set in stone. Thank you to SCOTUS. So we're looking forward to that. All right, so let me just share this. I'll share this Google document. Let me just share this. And then all of the decision links will be in there. Can I do that? Anyone with the link can see it. All right, so here is the link. This is where we're kind of keeping our notes right here to a Google Doc if you want to check that out. And then I'll pin that in the top of the chat so that you can check it out. That's literally this document right here. So at the bottom of this document, we've got all the links to all the decisions so that you can go peruse those at your leisure. But let's see if we get anything else today. And then we'll get into it because these were good. Very good. And if you're going to come out and say, apparently Alito said that if you're going to say that this is racially discriminatory, that's also going to likely fail. It's temporary for a reason. Now, I'm not trying to get too black-pilled on the birthright, right? There's many ways I think they could slice that apple. Hanging their hats on subject to the jurisdiction thereof, hanging it on residency. One thing Amy said I didn't have a chance to mention earlier was that Alito offered an off-the-cuff response to Sotomayor's dissent, which is highly unusual, according to Amy. That's interesting. So Sotomayor was just on a burner ranting and raving about racism at the border or whatever. And then Alito said, I'm going to deport your ass too. And she said, what? Something like that, you know. I'm sure he didn't say that, but we don't know what he said. But Amy was in the courtroom. And it would be nice if they would also broadcast these. There's a bill going through Congress right now. We covered it, I think, offhand, kind of incidentally. But one bill is making its way through that they'll put cameras in the courtroom. In the Supreme Court, which, you know, I can kind of go either way on that. I kind of like the audio only, but I do wish that we had more audio because it would be very nice to hear exactly what's going on and to hear that. She said, I didn't get the exact wording, but he said something along the lines of, there was much that I would have added to his statement from the bench. Almost like, oh, I didn't realize you were going to get up there and read your whole friggin' dissent in front of everybody. And if I knew that, there's much that I would have added too in response to your little screed. So that would be nice. Yeah, this guy says it too. Rory Little makes it much more obvious they should allow audio during opinion announcements. Exactly right. The video, you know, I could take or leave because I think the video, I'm not so worried about the judges exploiting video. I definitely think video should be applicable in all lower courts. So all the district courts, even Court of Appeals, I think would be good. But in the Supreme Court, I worry about the lawyers exploiting the video. You know, lawyers turning the whole thing into a circus, like a oversight hearing committee with Jasmine Crockett coming in and delivering oral arguments, you know. So I could see, and I kind of like the audio because it kind of leaves something to the imagination, but you would also like to see the facial expressions of the judges. Judge Alito going, oh gosh, it's Ketanji again. Or Ketanji fuming mad, shaking mad with her million questions. So we'll see if anything else drops right now. But we got some big ones. So 3 very nice victories on the border. 2 nice victories on the border, 1 victory on the gun case, and 1 Monsanto case. So we'll see if that's any good. But we're waiting to see if we can close this baby out. Yeah, and if, you know, you can kind of see the split. Like if we're getting some big victories on border security and the ability to manage the interior of the United States, we can cancel TPS status. We can turn people away at the border who come knocking on the door. We can close things down, right? We can actually kind of govern the people who are here. Then maybe they go the other way on Birthright. Maybe they say, well, if that's the case, we're going to give you all of these tools, but once you're here, we're going to count your babies. And we're done. All right, so Amy Howe says, okay, so to summarize before I sign off, we are done for the day. We'll get opinions on Monday, and we will have at least one more day after that. Okay, so mark your calendars, my friends. We'll be back on Monday as well for another decision day from the Supreme Court. But let's just hang tight just for a quick second. Then we'll jump in to our very first decision of the day, which is about TPS status. And so let's get our red pens queued up because we've got some decisions to review here on this lovely Thursday. Good wins. Very good wins. This is why the leftists are so mad about the Supreme Court. If you missed yesterday's show, we also literally showed the document where they're saying that if they ever get power again, they call it pro-democracy, which means pro-democratocracy, then they are going to pack the court. They put it in writing. They introduced it as a House resolution. They're going to nuke the filibuster. They already explained that. And this is why we cannot let them win. Thanks for joining us. That's the day. 8 decisions left, Birthright and others. Fed FTC removal may be coming on Monday. or maybe in the days following. So, all right. So we got some good stuff. Now, let's get in to the first one. We'll do the border stuff first. We'll do the gun case. Then we'll do Monsanto. And here we go. Big victory out of the Supreme Court of these United States, a 6-3 decision that says temporary protected status is temporary. And if a Homeland Security secretary, somebody like Kristi Noem, wants to come in and cancel it, she can do that without lower level courts preventing it from occurring. We see the decision just dropped, and as usual, it's an ideological split, but we do have an interesting concurrence here from Judge Clarence Thomas, seen here. But otherwise, the decision is brought to us by Judge Alito, joined by Roberts, Thomas, Kavanaugh. In full, Gorsuch and Barrett joined, except for Part 3A, Thomas with a concurrence, and the three leftists dissenting, led by Judge Kagan, Sotomayor, and Jackson. And Alito's going to kick this off. Let's skip the syllabus and get right into the meat and potatoes. He says, in these cases, we consider whether respondents, the TPSers who challenge the temporary protected status of aliens from Syria and Haiti, whether they are entitled to orders that postpone the terminations during litigation. They're suing. Kristi Noem came out and said, it's canceled. I'm allowed to do it. The statute says it's temporary, up to my discretion. The laws also passed by Congress say very limited judicial review. So she did it and then got sued. Then the lower level court said that decision is paused. It's stayed. Alito says, are they entitled to that stay, or can we start removing them? He says they are not entitled to a stay. This can be effectuated. He says the TPS statute plainly bars consideration of their non-constitutional claims. It allows no judicial review, quote, of any determination with respect to the termination. So when the secretary makes the decision, a judge can't say, well, I think your decision is bad for whatever reason, and I'm going to reverse you. No, it's in the law, 8 U.S. Code 1254A B5A. The term determination can be used to describe either an individual decision or the whole process. And under either understanding of the term, the law squarely bars all of the respondents' non-constitutional claims. So you don't get to substitute your judgment. Now, if you do make a constitutional claim, then that's up to the court to decide. You can't bar their judicial review as against the Constitution, Marbury versus Madison. But these are not constitutional claims. These are just discretionary decisions that are made by Homeland. Now, the sole constitutional claim that is actually before us will likely fail. Citing statements made by Trump and Kristi Noem, one of these respondents, one of the pro-TPSers, they say this is an equal protection problem. They say the only reason you terminated the Haitians' status is because of the racial makeup of the country's population. More racism. Saying, but ironically, one of the respondents' other arguments undermines that claim by offering a strong race-neutral explanation for the termination, namely that the current administration has terminated every TPS designation that has come up for renewal, every one of them, simply opposing the program, at least as it's been implemented in the past. So it's not racist as to you. We're not singling you out. It's for everybody across the board. And so for these reasons, Alito writes, the lower level court erred in granting relief and pausing the execution of the cancellation of the status. Time to pack up and go home. Congress created TPS in 1990, writes Alito, to provide short-term humanitarian relief for aliens who cannot safely return to their home countries because of some reason, armed conflict or natural disaster. Before then, the executive branch sometimes provided similar relief as a matter of discretion, even though they didn't have any authorization to do that. Then, as now, the Immigration and Nationality Act came through, And it allowed the executive, the presidency, to defer the removal of an alien who agrees to leave this country voluntarily. And let's not forget, while they're here and they're pumping out babies, those babies, under the current interpretation of birthright, see what the Supreme Court does on this, are citizens, not temporary. So they come temporarily, they pop out a bunch of babies, then it's hard to remove them because they've got U.S. citizenship kids. Before Congress created TPS, aliens had 30 days to leave, but the government claimed discretionary authority to extend that deadline indefinitely, and that's been effectuated. Beginning in 1960, the government used this mechanism to provide relief that was now furnished by TPS under a program that came to be known as EVD, Extended Voluntary Departure. The government authorized deferred departure for nationals where living conditions had become unsafe. They showed aliens from these countries and allowed them to remain in the United States until the government said, okay, it's safe to go home. And now, of course, it's never safe to go home because they want them here in perpetuity. Now, under that regime, the grant and termination of humanitarian relief was purely executive discretion. And judges on the Court of Appeals and elsewhere concluded that the executive's decision was unreviewable. Okay, President, Homeland grants you permission. Courts can't make a decision and reverse that. In fact, Judge Silberman, joined by 3 other judges, observed that a review of this decision would raise separation of power concerns because of the inherent executive power to control foreign affairs of the nation. And so a lot of this was delegated and has been delegated, citing a 1950 case. It goes to the executive. Now, after critics objected that extended voluntary departure lacked proper guidelines, Congress said, yeah, it does. Let's invade more. They created TPS, and it provides new standards on how to govern and terminate TPS. First, as with the EVD, the new TPS governance mechanism gives the executive branch discretion over whether to even designate a country as TPS. That responsibility lies with Homeland Security. The statute says Congress passed that the Homeland Secretary may, not shall, not must, but may, it's discretionary, designate a country for TPS if these conditions are met. Ongoing armed conflict and sending them home would be a serious threat. If there's an earthquake or flood or environmental disaster that is a problem, we can designate. There exist extraordinary or temporary conditions that prevent aliens who are nationals from going there. And basically, these created openings that you could drive a Mack truck through. And that happened my entire life, your entire life. Once a country receives TPS designation, certain nationals of the country qualify for work and they have immunity against removal. So they're basically here permanently. The second notable feature of TPS is that the law requires the government, and if they terminate it, you have to meet conditions. If they no longer meet conditions for the original status, you can terminate it. The secretary generally makes those designations when they do their ongoing review of TPS. They're instructed to do new reviews every 18 months. During that review, the secretary consults with other appropriate agencies and says, is it still necessary to have them here? If they take no action, TPS already gets extended for another 6 months. Now, these extensions continue until the secretary publishes a termination notice. And finally, the secretary's TPS designation decisions are not subject to judicial review. If they make the decision, that's the game. Some judge can't come in and say, well, I actually think it is still unsafe there. Christie says it's fine. You had an earthquake in Haiti 10 years ago. You're good. Go back home. Judge can't say, well, I've been to Haiti, or I read a book on it, or I saw a magazine or whatever. And so it is still dangerous down there. They're still doing voodoo or whatever. Can't substitute. You're not the secretary. You're a judge. The relevant provision says, quote, judicial review of any determination of the secretary with respect to the designation or termination is barred. You can't review it. Now, this is a double-edged sword because, as we saw with Mayorkas and Joe Biden, they brought him in. They said everybody had an emergency. Everything, was justifying extensions of TPS. And they even extended TPS in their final hours, right? Before they left office, they're like, another 18 months, another 18 months, another 18 months. Although designed to afford temporary relief, says Alito, TPS designations have often lasted for decades. For example, Somalia got designated in 1991, and look what that has done to Minnesota. 1991, still in effect 35 years later, got us Ilhan Omar. Tremendous. Because we brought them here and they had a bunch of babies. Now those babies are citizens. Now they have a very highly motivated, organized constituency, many of whom hate America, are ripping us off, building leering centers, defrauding the nation to the tune of billions of dollars. And we just have to eat it. 3 other countries retain designations that are more than 25 years old: Nicaragua, Honduras, and El Salvador. So Alito says the current administration, thank you, President Trump, objects to lengthy TPS designations. And they adopted a new restricted approach right after Trump came back. He issued an executive order called 14159, and he directed the government to now ensure that TPS is being granted consistent with the provisions of the law and only extended as long as necessary in order to fulfill the law. And under that approach, Homeland has now terminated every single TPS designation that has come up for renewal. So then they sued. Legal challenges began almost immediately because the foreign invaders have a massive legal lobby. This is how ridiculous it is. We invite them in as guests. Hi, you're here temporarily. Do you understand that? It's called TPS, which means temporary. Okay, you don't speak English? Okay, learn that one word because it's going to come back up very soon. Then you say, okay, time's up. We gave you temporary reprieve because we're nice people and it's time for you to go. They say, we're not going anywhere. Are you friggin' nuts? We're suing you. In opposing those challenges, the government front line of defense has been the judicial review bar. You can't substitute your judgment for ours. But the lower courts have consistently rebuffed that argument. The government once again laid that jurisdictional argument again after lower court judges were saying we can review. We are the secretary now because we want these people here indefinitely. So Trump then was postponed. He couldn't terminate these things. And so we granted review. Now, we granted review and said he can cancel them, but nevertheless, lower courts below us, and Alito should backhand all of them, including those cases now before us, have continued to block these attempted terminations of other designations. We already ruled on this as it relates to other countries, and they just did it again. Syria and Haiti and Burma and more. Now, the Secretary, Kristi Noem, designated Syria for TPS, not Kristi Noem, the prior secretary. Under 12, that would have been what, Obama. In 2012, because of, quote, extraordinary and temporary conditions related to Bashar al-Assad. Great. The initial notice recounted horrific conditions in the country, including the use of excessive force, killing, everything, disappearances, torture. I know. So we got to take care of everybody all across the planet. The notice recounted that Syrian military units and mercenaries terrorized the population, and they killed a bunch of people. These actions led military defectors and others, eventually causing a civil war. Now, for these reasons, they concluded that Syrian nationals can't go back because it's a hellscape over there. The secretary designated Syria for TPS for 18 months, and it's been 14 friggin' years. Syria has maintained its TPS designation through a series of extensions and redesignations, and once again, popping out babies, building out political constituencies and legal lobbies. Then in September 25, several months after we stayed another one, the first case involving Venezuela, the secretary came back out and said, you're gone. Syria, you got 60 days, pack your bags. She stated that she had consulted with appropriate agencies. She said, yeah, the civil war did cause a lot of problems and displacement, but in 24, the Assad regime fell and a transitional government took its place. So go home. The notice recounted the United States had normalized relations with Syria and had even revoked sanctions. Perfect. Now, even so, the termination notice acknowledged that serious problems remained. It noted that localized violence had replaced nationwide hostilities. Are there other countries that they can go to? It's a pretty big planet. Do they have to come here? Why is it our responsibility? It noted that localized violence had replaced nationwide hostilities. The secretary also recognized that most Syrians require humanitarian assistance, and it doesn't prevent nationals, though, from returning to safety. In short, the termination notice literally described improved conditions. But it wasn't a rosy picture. Based on this, the secretary determined that termination was required. And again, why are these people not in their homelands fixing their countries, right? If you have an escape hatch, then that creates a safety pressure relief valve. All of the good people who could fix the country and fight for their nation and solve these problems and actually improve the status, leave. You just leave. So the hellscape continues because there's no actual response internally. So asserting claims under the APA, 7 Syrians who we allowed in with our graciousness sued. You can't kick us out. We said it was temporary. Well, it's not for us. The district court concluded that they win. They're entitled to relief. They say another provision of the U.S. Code authorizes review in appropriate circumstances, and you can't do this. So it effectively postponed the cancellation. The court rejected the government's argument, saying you're not allowed to substitute your judgment for this. And the court claimed not to opine on the substance of this, but then it did. It proceeded to criticize the secretary, Kristi Noem, for taking a hatchet to the TPS system. You're so inhumane. You have to be the global steward of every single population that has a problem. And by the way, I don't want people to get killed in Syria. I'm not an inhumane person. I'm not saying that I want them to go there and get killed or die or suffer. But America can't take care of the whole planet. And our graciousness to all of these various populations is destroying our country, sucking down our resources, changing the demographic structure, bringing in a population of people that don't align with our values. So we have to do something about it. Now, the court found that the secretary's decision to terminate this was an anti-immigrant agenda, which they're allowed to be. We're allowed to be anti-immigrant. You understand that. That's what the law says, too. That if we don't have a reason to have you here that's justifiable from our interest, then it's time for you to go. It's not a constitutional requirement to be anti-immigrant. It's America. It's not a country for foreigners. The court then indefinitely postponed, said, I'm the president now. I run Homeland. The Second Circuit also denied the government's request because the Court of Appeals, many of these courts are filled with foreign aligned people or literal foreigners who became naturalized citizens, as we're seeing, foreign born judges. So it concluded that it had jurisdiction and that they did have a strong claim, and that Kristi Noem just didn't follow the appropriate procedure and didn't consult with other agencies before terminating the status. So now they're all reversed. You guys got blown out. So the government now came up to the Supreme Court. The Supreme Court, praise God, is now doing something very useful for America, granting cert and deciding this. They said, look, Haiti received a TPS designation after a devastating earthquake, killed or injured hundreds of thousands of residents. Devastating earthquake. Sucks totally. Maybe we could have all supported them in Haiti. Maybe we could have sent food down there. Maybe we could have sent resources and reconstruction efforts down there rather than bringing them all here. Are there other countries in Central America who can take them? Are there other entities in Africa or Europe or in Asia that can take them? Why do we have to do it? The government redesignated Haiti for TPS and extended that designation several times. In 2018, though, the government then attempted to terminate that status. So again, it is now 2026. The earthquake was in 2010. So in 2018, Under Trump 1, the government attempted to terminate this, but again, court orders said no, that's racism. In 21, following a change in the administration, the government then redesignated Haiti for TPS, not because of an earthquake. Joe Biden came in and he redesignated them because of gang violence and human rights abuses and poverty. You know what we have here in America? Poverty. We have inadequate health care in America. We have food insecurity in America. So how about we fix all of that before we become the purveyor and the stewards of the rest of the planet? Relying on these same grounds, again, it's just made up crap. Every country has poverty. Every country has healthcare problems. Every country has gang-related violence. Go look at Chicago. And the government continued to extend Haiti's TPS designation. So we have to import them here. So the net effect was to allow Haitians who benefit from this to retain status from 16 years. That's 16 years of Haitians dropping babies off in our country, becoming citizens, creating a Haitian lobby that then allowed them to sue and prevent the cancellation of this. Should have been canceled in 2018, but they bought another half decade into the country because stupid judges who are doing things illegally, courtesy of the Supreme Court now confirming that. In November 2025, then Kristi Noem put public notice, we're canceling you, time to leave. The last day of the most recent extension. And as I mentioned, Mayorkas and the Biden goons on their way out, they extended all of it to keep it maximum so that they could continue to ingrain themselves into our society. Now, stating that she had consulted with appropriate agencies, Kristi Noem, thanks to her for a great job on all this, she explained her assessment. She said, certain conditions are problematic down there. Yeah, there's gang violence and other things. And all that being said, I conclude that the ongoing designation of Haiti contravened the United States national interest. We have our own problems here. She noted, among other things, that many Haitians entered illegally, that many Haitians overstayed their visas. They had an exceptionally high rate of doing that, and the Haitian government was unable to provide information about who they were. Are they criminals? We don't know. Are they gang members? We don't know. But we import them in. The notice concluded by noting that the United States immigration policy must align with our foreign policy vision of a secure, sovereign, and self-reliant Haiti, and not a country that Haitian citizens continue to leave in large numbers to come here. And that happens. They were also piling under bridges. We don't know who they are. And I question whether they care about American values at all, or they're just here to exploit the system. If people from these countries shared our values, if they cared about due process and constitutional law and free speech and all of the things that make America what it is, why are they not building those in their home countries? Why has that not already been developed in their homelands? It's because they don't value those things. And that may say, it's colonialism. It's your fault that we don't have those things. Okay. So that means that in perpetuity, we have to take care of these people, bring them in, and then they form their own communities and they say, we're living on stolen land and they're entitled to be here forever, suing us for our kindness. That's what we get. So before the termination took effect, a group of 5 Haitians sued. Now we're violating their rights that we gave to them. They sued in a district court saying, you can't cancel us. They asserted claims under the APA. And by the way, these are leftists, many of them, who are running to their defense to make sure that they don't leave because they know that they're going to be supplicant, compliant constituencies that they'll envelop into the Democratic Party, which will further ingrain their power. They said this is a violation of the Haitians' equal rights because it was motivated by race. The district court said you win. It said that this is actually about how the secretary went into making her determination. I'm not substituting my judgment for hers, says the judge, but the process that she followed was illegal. So the Haitians get to stay forever. So on the merits, the court ruled that they were also likely going to succeed, saying that Christie acted arbitrarily and capriciously, and she ignored the evidence of Haiti's true country conditions. So Christie made a bad judgment, and the judge is going to substitute her judgment for Christie's, even though the statute says you can't do that. The court also ruled that the challengers would win on the equal protection claim. Now the Haitians have constitutional rights that are superior to our rights to elect a new Homeland Secretary under the president and then cancel these things. We can't do that. Their rights override ours. They're not even citizens. They were brought here temporarily, but they win, suggesting that this was racial animus and that Haitians and other non-white foreigners were under attack. The court prevented the removal. So then Alito continues. He says, a divided D.C. Circuit panel also likewise declined to issue a stay, saying, yep, stay here. It noted that many other courts have also found the same thing, and the government has not shown that it would suffer irreparable harm. So if you let him stay here, it's actually good for the country, even though Kristi Noem and President Trump and the American people who elected them said, we don't want this anymore. According to the majority, the government's assertion that the district court intruded into the executive branch was just a generalized assertion of injury. Now, Alito says Judge Walker dissented. He said the court, first of all, lacked jurisdiction under the law, and the government was irreparably harmed. This is the court intruding into the executive branch. After this decision, the government then sought a stay. We granted review, and here we go. So Alito writes, 6-3. We first start with their non-constitutional claims, and we conclude we are barred from reviewing them. The law literally says, Congress wrote this, there is no judicial review of any determination of the secretary with respect to the designation or the termination or the extension under this subsection. So again, Biden can come in or someone else, some communist can come in. And I think really, like, this is a real concern. They can just designate all of it. Oh no, it's there's poverty down there in communist Somalia or whatever. So bring them all in. So, but it works both ways. Two-way road. The text is clear. The plain meaning is very broad. We start with the term determination. What does it mean? It's a synonym for decision. Look it up in the dictionary, Oxford, Webster's, American Heritage. It says the act of coming to a decision. Not only is it the common use of the term determination, but other terms in judicial review bar this with respect to and more. So we can't substitute our judgment for the process that she made in coming to the judgment. And so under either of these definitions, the law bars the non-constitutional claims. You may not like the decision. You may disagree. Haiti's bad. They're eating cats and dogs, whatever down there. But you should maybe run and become president then, or become the Secretary of Homeland Security. You're a judge. You don't make those decisions. You're not accountable to the people via elections. You're only removable in impeachment. So we don't want you making these decisions. Congress articulated it goes to the president. Each claim concerns a discrete decision. For example, the decision to talk to the State Department. Homeland goes to Rubio and they say, what's going on in Syria? What's going on in Haiti? They're on the front lines. They're running the government. So they know what the status is. All of those steps were part of the process, and that is her determination. So in the same thing, that means that entire process is outside of the coloring lines. You don't get to go in there and write over it. So under any dictionary definition of determination, the judicial bar applies to respondents and their non-constitutional claims. So you lose. Decision is final. So we recognize that when a law is reasonably susceptible to divergent interpretation, we adopt a reading that comports with the traditional basic principles. But here, this text that says judges can't substitute their judgment overcomes the general presumption in favor of judicial review. So judges, you're blocked. Get out. Respondents in the court, below offers several theories to overcome this meaning. And this is where Alito is being very thorough. He's saying, okay, we can't do judicial review. There are other areas where we absolutely can do judicial review. You can't block the Supreme Court from measuring claims against the Constitution. That's their whole reason for existing, is to make sure things are not repugnant to the Constitution. The most prominent theory that they have to say, well, this is why we can overcome the limitation as to this discretionary decision, is that all that means is it applies to substantive claims, but not procedural errors. So judicial review is barred as to the underlying basis, but not, you still have to follow proper procedure. But he says, that's wrong. The law doesn't say that determination may be procedural or substantive. The law says determination, period. Take Doe's argument. So this is some TPSer. One TPSer said that Kristi Noem inadequately consulted with the State Department about Syria, saying she didn't get all the details. She didn't talk to them long enough. It wasn't as thorough as it needed to be. In proceeding as she did, the secretary, either personally or through her subordinates, made a series of procedural determinations. She could have sent an email. She could have sent a terse and unspecified email and then proceed to terminate the status after receiving a laconic answer. She did the process. That's her discretion. In attempting to limit that to just only substantive determinations, they also have not relied not on the statutory text, but they're relying on other decisions. They go back to 1991. They go back to 1986. But they're reading into those decisions way too much. McNary was about amnesty for agricultural farm workers. And that case involved an application for adjustment of status. Bowen, the other case they relied on, is not relevant. There, the court held that two other provisions did not bar judicial review of a regulation. The first provision didn't bar review at all, and it authorized judicial review under the law. And so that doesn't apply here because it doesn't mean determination. In this case, it's about determination. That's a whole separate conversation. And in another case, none of them are applicable. So by contrast, in this case, the law, TPS judicial review bar expressly restricts view. It is not a string cite that incorporates some other provision to a limited degree. They're not incorporating some other principle. It says it on its face. The text explains it unequivocally. And even if we were disposed to consult some other legislative history to determine the meaning of that, the proponents of the substance-only interpretation don't even cite legislative history, which is mostly made up. Legislative history is this legal philosophy. You talk about textualists, you talk about originalists. Originalism, what did the Constitution originally mean? Textualism, what does the statute actually say in the text? When those things don't support an argument, you have the living, breathing constitutioners who think that we can just go talk about legislative history. Well, there were debates about interpreting it this way, and someone else submitted a paper that was going to interpret it this way. And so the text, what it says, doesn't actually mean what it says because some senator somewhere had a different argument during the debates in committee. That's not how you govern a country. If that's what they meant, they can write it into the law and they're Congress so that they can revise this as necessary. But the TPSers, they say, while agreeing that it only applies to substantive bars, they advance another thesis that would reduce the reach of the provision even further. In their argument, they say in determination in the phrase, the judicial review bar only applies to the conditions in the country. And so, in other words, they're trying to give it special meaning. And we're wary of giving common terms technical special meaning. Statutory interpretation proceeds on the assumption that those who draft it, those who write it, enact a provision generally intended to mean what it says and mean what it says in ordinary usage. Without that assumption, the entire endeavor would break down. Everybody would just write something and they say, oh, actually what we meant is this. Well, why didn't you write it? You're Congress. Go put it in there. Ordinary people could not understand what the law requires because it would change every minute, and every word in a statute could be an unfathomable puzzle. Of course, a statute may provide expressly or may signal in some other clear way that it employs a common term in a way that departs from the ordinary meaning. But unless there's proof about that, without that proof of such a strong departure, commonly used terms should be given their common meaning. And here, determination is a common term. And therefore, they bear the burden of showing that it doesn't mean what it says, that it carries some other technical meaning that distinguishes between context and between substance and procedure and all this other crap. And it falls short of that. For example, the very first use of determination in the TPS statute refers to a determination with respect to eligibility for their benefits. In another provision, they also talk about determination. Another provision talks about extreme hardship. So 3 uses of the word determines are plainly not references to country conditions. It's about the process of coming to a determination. So they say, well, we don't need look at how the statute as a whole uses the term, but then so forget about how the word is defined in other areas in the same essential law. But just this one is very unique. And so you should limit here your ability to not review this. This argument, though, rests on a cramped view of statutory context. When we consider context, we value all the provisions to put it in its place. And while the use of a term in a nearby or closely related provision may be entitled to more weight, there is no justification for limiting this, as they explain. Once we expand our aperture, we see the statute uses determination in its ordinary sense, not to denote an assessment of country conditions. Meaning, the only thing we can't judge is country conditions, but we can judge the process. He says, no, determination means all of it. So taking a different tack, then the TPSers argue that only the secretary's ultimate determination, the final outcome, but not any other decisions, are unreviewable. So only one little part of the determination process you can't look at, but everything else you can. The dissent from Kagan makes a similar argument, but for reasons already explained, this argument is inconsistent with the plain meaning of the text. And that is true whether the term determination is understood to mean a discrete decision or the process. This argument also contradicts general law principles about how this works. And the important principle ensures that challengers cannot avoid a judicial review bar by creative pleading or clever lawyering and just take one bar, says you can't do this, and they say, well, what you only meant is I can't do this or I can't do that, but I can do all these other things. A bar means a bar. So moving beyond the text and the precedent now, the TPSers, they say then that our interpretation of the judicial review bar could protect many shocking abuses of TPS. For example, a rogue secretary in one fell swoop could issue a 50-year TPS designation. They say, oh, you just come out and, like I said, Mayorkas comes in and says all the Somalians are coming back. Anybody from anywhere that's got poverty, if you're feeling like a little broke, you spent too much money at the casino or whatever, come on in. That you could just extend that for 50 years. Or a secretary could determine that a TPS designation, well, just base it on a coin flip. The government says that each of these respondents are far-fetched hypotheticals and concludes that some, but not all, could be, in fact, redressed by the lower courts. But whether or not that assessment is correct, the fact remains that if a secretary engaged in the sort of conduct that they're imagining here, Congress would have ample means to stop that abuse, including, for example, through the annual appropriations process. They come in and say Somalia for 50 years. Sometimes Congress decides that a political process is the proper forum. And in sum, we hold that the TPS statute's judicial review bar applies to all non-constitutional claims. You can't look at it and reverse it. You lose. So then they say, okay, well, what about the equal protection claim, which is in the Constitution? We say that some of these others, MEOT, in a separate case, are saying, well, this is racism, and now you're treating one group of people differently, and they deserve equal protection. Saying, all right, well, let's talk about that now. We have held that where Congress intends to preclude judicial review of constitutional claims, its intent to do so must be very clear. In this case, we need not resolve this, because the TPS law is a clear statement rule, and we conclude that the respondents, their constitutional claim is unlikely to succeed. But before proceeding further, we briefly explain why we may address the substance of this equal protection claim without deciding whether the district court had jurisdiction over it. Now, it's a cardinal rule that a federal court may not consider the merits of a claim without first making a firm determination that they have jurisdiction over it. But when interim relief is sought, however, says Alito, a court does not make a final decision on any matter necessary to the ultimate judgment. The court only is making a predictive, not a final decision about the outcome of the case and the likelihood that the court has jurisdiction over a claim and the likelihood the claim is going to be meritorious. Both bear on the ultimate prospects. So in evaluating the likelihood of success question for the purpose of ruling for interim relief, remember, because there was just a stay on this, courts may consider the likelihood that they have jurisdiction and whether that claimant is going to succeed. If they conclude that a claim fails on either a ground, they must deny relief because you're going to lose. Here, we review the district court's award of interim relief. And so in evaluating their likelihood of success on their equal protection claim, we may reverse the grant of interim relief on either jurisdiction or on the merits. Now let's get to the merits of the claim. They say that this is an equal protection problem because of racism. The government says this should be a deferential test and follow Trump versus Hawaii, a 2018 case that identified the proper standard of review for weighing their claims against the Constitution. The factors include the executive's broad authority over the admission and exclusion of foreign nationals and immigration policy and foreign relations. So you have to consider all of that. They say, you're being racist to me. We're saying, no, we're not. It's about foreign nationals, foreign relations, immigration, and the broad authority of the executive branch delegated under the Constitution. They say, no, that's not the right standard. It should be heightened scrutiny. In their view, it should be about race, essentially. But Alito says, we don't need to resolve this. We will assume, for the sake of argument here, that the Arlington Heights standard, which is kind of weighing people's race when aliens are being excluded, he says, let's use their standard. Let's say we have to analyze under your standard. Was there a discriminatory purpose and whether that purpose was a motivating factor in the decision to terminate TPS? Now, but because application of that standard calls for consideration of the context in which the statement was made, the immigration context is an important factor. So in support of their claim that the termination of the Haitian status was based on race, they cite statements by Trump and Noem. The president's comments fall into four main categories. First, many express strong objections to the immigration that this country has experienced in recent decades and to many of the immigrants who've come here, particularly those that have come here and stayed here illegally. These statements associate these immigrants with crime and other social ills, as we're seeing. Second, some statements express great displeasure with TPS. They note, among other things, that these designations have been far from temporary and that aliens who are allowed to stay in the U.S. under the program are not vetted like others. They just pour in. Third, some statements broadly denigrate the countries for which designations have been granted, including Haiti, portraying them as hellish dumpsters. And fourth, some other statements malign Haitians who have come to the United States. They're eating the cats, they're eating the dogs, eat the cats, eat the cats. MEOT respondents also cite statements by Secretary Noem. Some expressed antipathy toward travelers from country covered by the travel ban. Others were derogatory comments about immigrants and its effects in immigration. And which we are allowed to say, by the way, these are massive policies that impact all of us. And still some others promised changes and criticized past implementations. Now, none of the cited statements by any of them were overtly racial. In substance, all expressed policy views that could rest on race-neutral justifications. For example, one may oppose TPS and favor tighter restrictions on immigration for economic or other reasons that have nothing to do with race. And a person without racial bias can provide a harshly unfavorable description of some of these countries. The criteria for these designations guarantee that many, if not most, designated countries actually do have these characteristics. That's why they were granted TPS in the first place. And Haiti is no exception. It is a very poor country, and living conditions there are unquestionably difficult, says Alito. Many Americans of all races would surely find those conditions intolerable. But poverty and deprivation are no reflection on character, and there is no justification for denigrating the character of Haitians who suffer from and bear no responsibility for their country's ills. That's pretty gracious of him. Due in large part to the difficulty and the difficult conditions at home, many Haitians have come to this country throughout our history, and beginning with the more than 500 Haitians who fought to support American independence at the Battle of Savannah in 1779, Haitians have made many positive contributions to the U.S. from the very beginning, and they continue to do so today. And so in offering the cited statements as proof that termination was motivated by race, they seek to capitalize on statements and the heated language. Political discourse by prominent officials is increasingly couched in terms that would have scandalized the public a long time ago, and statements, especially those about Haiti and immigrants, exemplify this. But whatever one may think of the statements by Trump or no, they are insufficient to stop the cancellation based on racism. Ironically, both the respondents, the TPSers, identify strong race-neutral explanations of these, saying the administration doesn't like immigration, and neither do the American people, which is why we elected him twice. Respondents argue that the secretary made preordained decisions to end TPS for all countries. In other words, they didn't even do an analysis. Like they canceled for Nepal and Burma and Afghanistan and Syria and Yemen and Somalia and Ethiopia and South Sudan and Cameroon and Nicaragua and Honduras and Venezuela and Haiti. Look at this crap. It's the whole country, whole planet into our country. Most would regard this as a racially diverse group of countries, but he says they're all non-white. They claim that TPS has not been terminated for predominantly white nations and therefore infer that the reason for the termination was having predominantly non-whites. So their definition of a predominantly non-white nation is broad. Apparently, it even encompasses major European countries. It may be that only the termination of TPS for a Nordic or Germanic country would be sufficient in their judgment that this was race neutral. However, no such test has come up during the present administration. Only one European nation, Ukraine, had a TPS designation when Trump began his second term, and that hasn't come up for review yet. The only other European states designated are war-torn provinces in Kosovo and Bosnia. The great majority of countries granted TPS have ranked among the poorest nations of the world, and no European nation falls into that category. Viewing all the relevant evidence, we conclude that respondents are unlikely to prove that race was a motivating factor. It's not racism, and so it follows they are not entitled to interim relief on their equal protection claim, and so the judgments from the Southern District of New York and D.C. are hereby reversed. The cases are remanded for further proceedings consistent with this opinion. It is so ordered in a 6-3 burner. And here's Clarence Thomas, who's confirming. A certified black man. He says, I join the opinion of the court in full. And I write separately to address two more fundamental problems with their lawsuit. The first is this equal protection claim. While meritless under our precedents, was also beyond the district court's jurisdiction. And second, even assuming jurisdiction, the equal protection claim fails for another reason, because aliens have no equal protection rights against the federal government. Thank you, Clarence Thomas. Cue the Clarence Thomas is a white supremacist. Clarence Thomas is a bigot who hates aliens and black people. They have no equal protection rights against the federal government. They're here as guests. The law precludes district courts from even reviewing TPS. It provides that there is no judicial review of this at all. And as the court explains, this bar precludes the statutory claims challenging the determination. The court does not decide, though, whether their equal protection claim is barred as well. But in my view, the equal protection claim is also barred. It says judicial review bar. We don't want them to come here and make constitutional arguments, period. Respondents asked the federal court to set aside this because it was unconstitutional. He says that means everything. Even your this is racist, even your this is ethnic, whatever, all that's gone too. By asking for a court order to invalidate this decision, that's what the statute does. Judicial review means across the board. And so therefore, for the same reasons as their statutory claims being barred, their constitutional claim is also barred. It challenges the process that led to the decision, and it's barred across the board. Now, this is a concurrence, right? So it's not in the majority, so this is not going to be a part of the holding, but he's making his point. Respondents say the plain language of the statute should not apply. According to the modern precedents, constitutional avoidance requires a clear statement. Barring all claims, here, they say it raises a serious constitutional question. And so accordingly, the argument goes, courts should avoid interpreting a statute to have barred such review unless intent to do so was clear. And respondents appear to doubt, and I'm unconvinced. First, the law makes Congress's intent to preclude judicial review clear. It's unambiguous. Alito crushed that for us. There's no indication in the law that was written that reviewability turns on the source of law, whether it's a federal statute under TPS or whether it's a constitutional equal protection claim. It follows that constitutional avoidance has no role here. And second, even if this were ambiguous, a judicial review bar would raise no serious constitutional questions in the first place, because inferior federal courts are creatures of statute. The Supreme Court is articulated in the Constitution, and Congress can create other courts as necessary pursuant to Article 1, Section 8, Clause 9. So they have no jurisdiction except that which is given to them. So the Supreme Court can weigh the constitutional claims, but the lower courts can't because Congress didn't give it to them. They actually took it away. So Congress can deprive district courts of the jurisdiction to decide these types of claims. Now, it makes no difference that they say it's a violation of the Constitution. Even Scalia said it. He said, what could possibly be the basis for doubting Congress's authority to bar judicial review of constitutional claims? The very text of the Constitution refutes the principle that all constitutional violations must be remedial by the courts. And in some cases, a question of constitutional law is textually committed to adjudication by another branch. About how like the House governs itself, the courts govern themselves, the senators govern themselves. Other principles exist in this basis. An obvious one is sovereign immunity. Because sovereign immunity, no one can sue the federal government for damages without a waiver. So we can limit these types of claims, and therefore the Constitution does not require that courts hear all constitutional claims, especially from foreign invaders. So Congress barred all judicial review, not just the statutory claims. Alito's majority really went to the statutory claims, but said you're also going to fail on the merits of the equal protection claim. Respondents' equal protection claim also has no basis in the Constitution. There is only one EPC, and it applies to the states, not to the federal government. And so they sued the federal government. When asked at argument how the Equal Protection Clause could have anything to do with a lawsuit against the federal government, their lawyers for TPS said, well, it comes from equal protection under the Fifth Amendment. But he says, that's not in there. The Fifth Amendment has no equal protection clause, and so this court shouldn't have read it into the due process clause. And even if the due process clause in the Fifth Amendment does prohibit some discrimination, it doesn't do so in an immigration case. And so there was little evidence for the court's modern assumption that due process contains equal protection, whose substance is precisely the same as the EPC in the 14th Amendment. The clause says nothing about equal protection in there at all. Reading an implicit equal protection component into the Fifth Amendment renders incomprehensible the 14th Amendment inclusion of an identical due process clause and equal protection clause. History has no basis for this at all. Now, even if the due process clause did include some non-discrimination principle, it would have no application here. That restricts the government's ability to deprive people of life, liberty, and property. Termination of status does not deprive them of life, liberty, or property, so they have no claims about this. And they can't make a discriminatory claim. The discretionary and limited law and status of the TPS designation provides, like any immigration status for aliens, It's a government created privilege. It's not a core private right. But they come here and they say there are rights now, and we're going to sue you to enforce them. And so perhaps for these reasons, this court has never subjected even express racial classifications in immigration laws to scrutiny under the Due Process Clause, while foreigners have long been able to claim constitutional protections from racial discrimination by the states. They've never been guaranteed a right to immigration status or citizenship based on equal protection, even when these laws were openly discriminatory. Citing them going back, Congress only amended the laws to eliminate that discrimination in the middle of the 20th century. And so if equal protection applied to immigration, much of our current immigration law would be in conflict. Our laws, though, have distinguished among aliens based on their national origin since the beginning. Some immigrants are more beneficial than other immigrants. It's just a fact. Today, applicants for immigration are treated differently based on their nationality as a matter of course. And respondents themselves seek protection from deportation from people from Haiti, but not the neighboring Dominican Republic. And so if they're correct that the court should apply equal protection, then the program that they benefit from may ironically be unconstitutional, courtesy of Clarence Thomas in a major concurrence. And here's the dissent. We'll just hit the highlights of this one. But Kagan wrote this. Here you see lots of, it's my oppression, 2010 earthquakes, and now they're canceling it. Today, the court undoes this relief. And second, the majority says that they see no evidence that race played any role. Okay, so it's going to be racism. So there is no dispute that they're going to suffer irreparable harm. So her argument, if you send them home, they're going to have to go back to their home country. Got it. So I think that they should have a stay in this country and stay here while these lawsuits go forward. And so respectfully, I dissent. Goes through the history of the designations, saying we're not actually barred. It doesn't stop the court from reviewing things other than the secretary's determination. We're allowed to review all of those things. We just can't review the final determination. And so in the process of coming to the determination, we can find that something there was invalid. And it's the opposite of the Alito argument. I think we get the gist of it. And in some, let's see where she leaves it. Again, it's racist. The Haiti plaintiffs must show that there was a racially discriminatory purpose. And let's see if she calls out any of these comments. Yeah, here she does. Here's some interesting quotes. Oh, yeah. They're eating the dogs, eating the cats, eat the cats, era eat the cats, that song. They're eating the pets of people that live in Springfield, Ohio. And Haitians are also eating other things, too, that they're not supposed to be. And they probably have AIDS, says somebody. And they're filthy, dirty, and disgusting, says someone else. And it's a shithole country. And the Haitian immigration is like a death wish for our country. It's true. And why is it that they only take people from shithole countries like Haiti and Somalia? Swear jar a couple of times, but it's from the Supreme Court, so we get a pass. The majority briefly replies that those remarks are not overtly racial. And I mean, they're not. They're national. They're from Haiti. They're from Somalia. They're Haitians. It's not race. It's a nation. It's a nation of origin. So, yeah, I mean, they could be whatever color they want. If they're eating cats and dogs, they're not a real good fit for America. So this is her section on racism. So everybody's a racist. So if you do anything racist, then everybody from that country gets to live in America for all eternity. And so according to Kagan, she says they're entitled to relief. If we send them back to their home country, they're all going to die. It's going to be life-threatening and they're going to be injured and blah, blah, blah. So we got to take care of them. But nope, Supreme Court said, no, we don't. And your claim to stop the cancellation of TPS now fails 6-3 in a great decision, courtesy of the Supreme Court. And it'll go back down to the lower level courts. We'll see if the lower level courts then, because this didn't go as far as to say that they can't review the equal protection claim. So maybe they'll find some threshold in there. Thomas had the concurrence that said that you can't do that. But once again, they joined except as to Part 3A. So Gorsuch and Barrett joined except as to Part 3A. Let's just take a look at what that one was again while we're here, so we know what they did not join. Scroll on down. What section was that? 3. So they're not joining. Where is 3A? Let's just see section 3. So maybe as to the equal protection claim. So, okay, so Gorsuch and Barrett are not joining on the equal protection claim. That's 3A right here. Which means maybe the lower courts try to finagle something in there about the equal protection claim. But Alito and Thomas, of course, would nuke that. And then we've got Kavanaugh and Roberts. So we'll see if this ultimately comes back. I wouldn't put it past the lower level courts to try to undermine that in that arena. Like, that's the avenue that I would take if I were a TPS Haitian invader. But as it stands, a very solid decision. The judicial review is barred as to these other procedural claims, which is really where they were hanging their hats on. And there are other explanations and justifications for why this type of status is bad. It's not overtly racist. Some immigration from some countries are much better than other countries because they contribute to America. And we're allowed to have that conversation here. We don't have to just say we have to take everybody from anywhere, even if they're wrecking your country. That's a suicidal nation. That's not what we are. The Supreme Court found accordingly. Congress wrote it into law. They don't like it. They can change it. But as it stands, TPS, the cancellation is back on the menu, baby. And so the proceedings can continue forward. So hopefully the Haitians are packing their cats and dogs and getting ready to leave. We'll keep our eye on this one as it reinvigorates throughout the system. Thanks for joining as we do. All right, we got another good one, a border case. And let's see, this one also, I believe, is from Alito. And let's see. Yeah, this is another 6-3. Thomas again with a concurrence. Here is this one. Massive victory out of the Supreme Court as it relates to the border. What happens when foreign invaders come to the border? Can they be categorized as being in the United States for immigration purposes and then become the beneficiaries of all that that status affords? The Supreme Court today, in a 6-3 decision split along ideological lines, says no, you're not actually in the United States. And the decision brought to us by Judge Samuel Alito. He's joined by John Roberts. We got Thomas, Gorsuch, Kavanaugh, Amy Coney Barrett, all joining in. Thomas also with a concurrence. And then Sotomayor, apparently with a fuming mad dissent. She spent a long time during the decision day in the Supreme Court ranting through it. She's joined by Kagan and Jackson. Jackson also filed a dissent as well. So here is what Alito wrote for us. He says, you know, this case presents a pretty straightforward question. Whether an alien who seeks to enter the United States from Mexico, quote, arrives in the United States when he or she is still in Mexico. Do you arrive in the United States for the purposes of law when you're literally physically still in Mexico? In the decision below, the United States Court of Appeals said, yes, you are. You're physically over there, but technically you're in here. That is wrong. Simple. In ordinary speech, no one would say that a person arrives in a place, for example, in a house, in a city, or in a country, before they actually enter that place. And so the context in which the phrase arrives in the United States is used in the immigration statutes at issue here supports an ordinary meaning reading. So does the presumption against extraterritoriality. And so therefore, we reverse, courtesy of SCOTUS. Now, he gives us some background. He says, okay, there are two sections of the Immigration and Nationality Act. They're central to this dispute. Congress adopted both provisions, and it contains the phrase, quote, arrives in the United States. First, 8 U.S. Code 1225A governs the inspection of aliens who seek admission to the United States. An alien who wishes to enter the U.S. must lawfully first be admitted. As used in the INA, admission is a term of art that means lawful entry of an alien into the United States after inspection and authorization. So, an alien cannot lawfully enter the country without first being inspected by an immigration officer. And an immigration officer must inspect all aliens who are applicants for admission or otherwise seeking admission. An alien is deemed an applicant for admission if he arrives in the United States. The government, correspondingly, must inspect an alien who arrives in the United States. Let's say, for example, if they show up in California at a port of entry through which millions of people pass, but an alien is not entitled to inspection until he arrives in the United States. The meaning of the phrase arrives in, accordingly, determines whether and when the government must inspect an alien seeking to enter the country. The second is another key statute. During inspection, an immigration officer decides whether an alien is inadmissible under another law, which bars entry on grounds related to other things, national security, foreign policy, aliens' health, or criminal activity. If the officer concludes that the alien is inadmissible, the officer must then generally order the alien removed without a further hearing or review. It's called expedited removal. And an officer may not proceed with expedited removal, however, if the alien indicates an intention of applying for asylum under 1158, and we now know expedited removal is also back in play. So in that event, the immigration officer must refer the alien to an asylum officer for what's known as a credible fear interview. I'm under attack, my papusa business. If the officer says that they don't have credible fear, then they must order them removed. But if they say that they do have credible fear, then they detain the alien for further consideration. Now, asylum is a status that entitles an alien who is, quote, a refugee to remain and work in the United States. A refugee is an alien who is unable or unwilling to return to the country of origin because he says, I'm going to be persecuted. There's a well-founded fear of persecution because my race is under attack. My religion is under attack. My nationality is under attack. My membership in a particular group like the trans barber from Guatemala. Or because my political opinion. So any reason I'm under attack and now I'm a refugee. Now, any alien who arrives in the United States may apply for asylum. And the AG or homeland may, but need not, grant such an application. So in sum, an alien that arrives in the United States is entitled to this process. They can come here, they can get inspected, they can be deemed somebody who is an applicant, then they may apply for asylum. But if until that happens, if you're arriving at, you're not in, then you're not entitled to that inspection. You're not entitled to be considered an applicant, and you cannot stay and apply for asylum. So if you come to, but you're not in, sorry, you're cut off. In the spring of 16, Border Patrol began to experience a surge of aliens at ports of entry along the Mexican border. The number of aliens seeking to enter sometimes far exceeded the number of people we could process. Long delays slowed the inspection process, and Border Patrol ran short of chairs, meals, and beds. The resulting conditions were often unsafe for aliens, and they rendered facilities unsecure. In November 16, under Trump, no, not Trump yet. Trump comes in at 17. Obama was still in charge at this time. So they then began metering the number of aliens whom CBP would inspect each day and then allow to apply for asylum. To enforce the policy, officials stood at the U.S. side of the border and prevented entry into the United States by more aliens than the ports could process. So it's like, oh, just take a number, get in line like a deli. Come into America here, take a number. The metering policy continued through the change in presidential administrations. Then in April 18, a Border Patrol official under Trump distributed a memo that allowed offices to meter the flow when necessary and to maintain security. The memo also empowered offices to establish and operate physical access controls, including as close to the border as feasible. But officers could not discourage an alien from waiting to be processed if the alien claimed a fear of return or any other protection, which they all just make up. And they're taught that. They got pamphlets how to get in. And the memo stated that an alien must be fully processed once the alien is in the United States. The government reiterated this process, this one issued by the Secretary of Homeland Security. He says in 17, asylum seekers and the immigration advocacy organization called Al Otro Lado brought a class action lawsuit against the U.S. once Trump came in. Respondent argued that the enforcement of this metering policy was limiting people who arrived at the border, sought an injunction. The district court certified a class of all non-citizens who want to be in the asylum process and bundled them into this giant lawsuit. The court then granted summary judgment and said, if you are in the process of arriving in the United States, you can't be prohibited from doing that. A divided panel of the Ninth Circuit affirmed in the relevant part. They said an alien arrives in the United States and thus must be inspected and put in this asylum process, even while standing on the Mexican side of the border. If they encounter a U.S. official, that means they are arriving in the U.S. The majority based this on other language and said in is close enough, even if you're not actually in. They said in the United States, the government said, means in. Only when you enter the country. The phrase arrives in the United States means physically present inside the border, and stuck by that. The Ninth Circuit called for briefing. We had a whole hearing on this and said that in is good enough. So the Supreme Court granted cert, and now they write, we hold that an alien who is standing in Mexico does not arrive in the United States by attempting and failing to set foot in this country. So you're not in the asylum refugee process. An alien arrives in the United States only when he crosses the border. Why? That's what the law says. We consider the phrase, what does it mean to arrive in the United States? We use it every day. The meaning is very clear. A person arrives in a geographic location only when he enters it. To arrive is to reach a destination. Look at American Heritage Dictionary. Look at Webster's. Look at Oxford. The preposition in means within. On these definitions, a person arrives in a destination when he enters within its area, not before it. So everyday examples confirm that. A running back does not arrive in the end zone when he reaches the 1 yard line. Nice. A guest does not arrive in a house when he knocks on the door. An army does not arrive in a city by encamping outside its walls. And a letter does not arrive in a mailbox while it remains in the mail carrier's hand just inches away. Respondents, though, suggest the meaning of the phrase arrives in shifts to when someone blocks the way of the person seeking to arrive. In that circumstances, they say, well, he is in, but you're like now blocking him. So on their view, a person does arrive in a house when, although he is not in the house and is merely ready to take the step over the threshold, and the homeowner stands on the other side and prevents the entry. So put simply, an alien arrives in by attempting to come in the United States. He says, we disagree. We return to our earlier examples. Okay, the running back does not arrive in the end zone when the linebacker is about to hammer him. And 6 points do not go up on the board when he is tackled at the 1 yard line by the defense. The guest does not arrive in the house when the homeowner locks the door right before the guest tries to open it. The army does not arrive in the city when the city's defenders repel the attack outside the city limits. And the letter does not arrive in the mailbox when the dog assaults the carrier a step away from the mailbox. A person arrives in a destination, says Alito, only when he enters it. And that conclusion does not change because someone or something blocks entry. A person arrives in the United States only when he enters it. Several features of the law also comport and confirm that. Other provisions talk about actual entrance and use that word. Others use attempted entrance. For example, other phrases say that explicitly. But this says in, and we are required to give Congress's rules effect. What they wrote, we have to follow. Second, they also talk about aliens who arrive near a land border. So they talk about that, so they know what these words mean. And third, Congress could have easily required immigration officers and changed it to arrives at, or if you reach the U.S. border or arrives at the border, then we could hear you. And it could have used similar language in specifying which aliens apply for asylum. But that's not in there. In other places, they have talked about at a land border or at a port of entry, could have been a part of it, but that's not what this phrase is. And fourth, that Congress amended this other provision of the IIRA to replace at a land border or port of entry with arrives in the United States means it should be different. They changed it. The original incantation of this was at a land border or port of entry. They changed it to arrive in the United States. Those are different meanings. And you say we should not read those phrases, which are different, to have the same meaning. We're not going to do that. They say that in our interpretation of the phrase arrives in puts way too much weight on the preposition in. According to them, in doesn't mean anything. It would make no sense to say someone arrives at the United States, but it would easily. Congress could have said that, no problem. Could have easily said arrives at the border or upon a spot adjacent to the border. They didn't do that. So then they say that it's essentially close enough. They say it's redundant, and arrives in must apply to people who are not geographically present. It just makes sense in the context of the other laws. Now, although that argument has some force, Alito concedes, in the end, it does not overcome the arguments that point the opposite way. The anti-surplusage canon is not an iron rule, and as Justice Scalia put it, the canon expresses our general reluctance to treat terms as surplusage, just unnecessary additions. The canon is based on an inference about how a careful writer or drafter of laws ordinarily uses language, but even excellent writers do not always trim every unnecessary word. The same is true of Congress. So we have acknowledged that Congress sometimes enacts provisions that are superfluous. That doesn't negate the meaning of this phrase. And the most plausible explanation is the link between arrives in. Both were added by the by prior law. Before then, aliens who were physically present could apply, but no provision of the INA authorized expedited removal. Expedited removal would begin when an alien arrives in the United States, is inspected, and deemed not admissible. Careful writer or drafter may sometimes include language that is not strictly necessary. And so for these reasons, the redundancy that troubled the Ninth Circuit is understandable. Like some of the repeat words are kind of, concerning. But at any rate, if forced to choose between an interpretation that entails some redundancy and one that contradicts what words actually mean, we're going to choose the redundancy and follow the language of the words. Even if text and context were not enough to reject these arguments, the presumption against extraterritoriality would tip the scale. We have to consider what is in our territory, what is inside our jurisdiction. Does the law apply outside of our borders or inside the borders? We have sometimes used a presumption against extraterritoriality, and here we're determining a phrase about immigration inside. So the answer is plain. Nothing in the law would reverse the unmistakable congressional intent to require that aliens be inspected in while they are still outside. They have to be in order to do what follows from the law. And so the remaining arguments fail. Our precedent overrides the cases that they are citing. Because aliens who were standing in Mexico are outside the territory of the United States, the refusal to allow them to enter does not violate other provisions of the law. And they say that this will create perverse incentives to encourage them to enter the country illegally. And so according to them, if border officials turn them away at a port of entry and deny them the chance to apply for asylum, they'll just come in illegally. That concern is overstated, and in any event, can't defeat this. Metering does not permanently bar any alien from arriving in the United States. It merely delays the date when some may enter. Illegal entry, on the other hand, may be expensive and dangerous and has adverse legal effects. Entry is a crime. An alien becomes ineligible for asylum if he unlawfully re-enters after having been removed. And it should be from the very beginning. If you come in illegally, no asylum, no refugee, nothing. It should be from the very first instance. And an alien unlawfully present is ineligible for government benefits, but they get them anyways thanks to the crap states. So last, respondents argue that acceptance of this interpretation, we adopt a drastic harm that might prevent potential asylum applicants from ever coming here. Great. For future present purposes, it also suffices to say that the rescinded metering policy was never anything like that imagined future policy, and the policy merely delayed some other aliens from being here. And the wisdom of this policy is not before us. We decide only that an alien standing in Mexico does not arrive in the United States. Pretty simple. The law neither entitles that alien to apply for asylum, nor requires an immigration officer to inspect him. And so as long as they're over there, they don't have to come here. Simple as. You're not in. So we reverse the judgment of the Ninth Circuit, remand this case for future proceedings consistent with the opinion. That's 22 pages. And then Sotomayor just drops essentially the rest of it. Let's see what Thomas has to say. And we'll hit the highlights of the Thomas concurrence. He says the court's opinion is correct. In Mexico, I join it in full. I write separately to address two further problems with the decision below. First, the lower court appeared to effectively grant class-wide injunctive relief. We have already prohibited this. You're not allowed to give this type of remedy. And second, the relief that they provided may also have unconstitutionally infringed on the president's inherent authority to exclude aliens from the country. Let's go. He says the only exception for immigration, regardless of the nature or action, you are stripped, lower courts are stripped of judicial and jurisdiction authority to enjoin or to restrain the operation of this on a class-wide basis. You had no right to even enter this decision in the first place. The district court certified their class of non-citizens to everybody across the board, then asked the court for an injunction. The district court acknowledged that our interpretation barred this relief, saying, oh, we actually can't do this. It correctly concluded that the law that we handed down from SCOTUS squarely controls the case. But nonetheless, then, they effectively granted them what they asked for. Even after our decisions in Gonzalez, the Ninth Circuit maintains that this other section allows class-wide declaratory relief. To say this whole thing is unlawful. They invoked other provisions of the law and bypassed what the Supreme Court told them to do. And so in a future case, we should address this. They did an end run around our Supreme Court precedent using some other statute. And I'm skeptical that the relief that they ordered actually even complies with that statute. That says no court may enjoin or restrain the operation of another section. And so they latched onto something else to do what we told them they can't do. And even if some declaratory relief are compatible with that statute, the relief entered here is not. The government was subject to a declaration that this was illegal as to all class members. The court has repeatedly reserved these questions for future decisions. And so the Ninth Circuit and the lower court were clearly erroneous in their merits holding. So the court should soon address these things and why these courts are evading using that law. And separately, the president has inherent authority to exclude aliens. We decided that back in 2018. There is founding era evidence showing that the executive power of Article 2 includes the power to deport. For example, William Blackstone explained that the king could send alien friends home whenever he sees fit. And Congress has no enumerated power to require the president to bring certain aliens into the country. The Constitution grants Congress the power to establish uniform rules of naturalization. But these class members are not naturalized, and they're not on the path for naturalization at all. And so Congress may only pass laws which shall be necessary and proper for carrying into execution powers of the other branches of government, but that is not what they did here. So any law that forced the president to allow aliens to cross the border against his will would exceed congressional powers, and a court could not enforce it against the president. Man, so broad powers is what Thomas is saying are actually due to the president. And if he wants to restrict these aliens, he can do it. Thank you, Judge Thomas, in a concurrence. Of course, that's not part of the majority. But then Sotomayor came out. She's now got 40 pages of a dissent. She was screeching about it all day today during the delivering of the opinions. And she says the word in. You guys are just fixated on this, but you have to read it in context. And so at our doorstep is her preferred interpretation. So we have to know what metering is. We got 20 ports of entry. Bunch of people were invading, and at the border is good enough to accept them in. They said it's about resources. We're always kind of looking for her racism claims. One woman who fled Honduras after receiving death threats from gang members was cut, knocked unconscious, and beaten by an unknown man, and then got to the port and was turned away. Yeah, because she shouldn't have come in the first place. Okay. Her home country should fix all of that stuff. We're sorry that happened to her. We hope she's fine and well. But we incentivize this idea that you could escape reality by just coming to our country and we would take care of you. We just physically, literally cannot do it. So again, it's a bunch of sob stories here. Someone else came across the Rio Grande. Someone else spent a month trying to cross a river. Another woman drowned. She shouldn't have done that. She shouldn't have been brought here by your leftist, liberal, psycho policies. Why are you incentivizing these people to go through this trial and tribulation to get here? Other young kids drowning. Yeah, the illegals raping each other on the way into the border, throwing their, abandoning their kids in the rivers and more. We don't want that type of bedlam and that type of madness. They wouldn't have done these things if it wasn't possible to get in. So by you enabling them to come in, you've created this environment, not us. But now we have to enable it and allow it to continue to happen because the very policy that we created causes them harm. And so since we created a crap policy that's causing them harm, we have to then accelerate the policy and make it more broad. Just don't have the policy. Just say you're not coming in. There is no asylum. There is no refugee status. Just don't come. Do we have thousands of Haitians under a bridge in Texas right now? No, we don't. Because Trump said, you're done. It's cut off. So they're not coming anymore. Weird. Are women getting raped at the border? No, because no one's coming to the border because it's not allowed. So the Ninth Circuit said that, of course, in means at, and we can do whatever we want. So their own stupid policies are causing all of these damages. So you get the point. She says at and arriving in, we just need to use it in context. She just takes the opposite position here. That's Sotomayor. You can see how mad she is. That's why she was ranting about this during the deliverance of the opinions today. But all said and done, as we see from the holding, 6-3, arriving at the border is not in the border. We're not obligated to take you and shove you through all of the asylum refugee processes just because you got here and made a long journey and a long trek. You should have confirmed what the status was before you made that journey. And really, if these people are all amazing people and they're all coming in to be, for the benefit of America, why don't they just stay in their home countries and benefit their home countries and fix the nations rather than allowing the bad actors to continue to control everything while America acts as the safety relief valve for all of the problems of the world? Great decision from SCOTUS. In means in, and they're not in the country. Happy to see it. We'll see what the fallout from this one is. Thanks for subscribing to our channel, as we do. All right, we got another big one, and then we'll hit the Monsanto case. This one also about the Second Amendment. We had the Hamani case that came out, I think that was on Tuesday or last week. But here is a victory out of Hawaii. And I was just reading that, but I didn't read what I was looking at. Kagan, Jackson, another 6-3. Tremendous. All right, here we go. Victory out of the Supreme Court, a 6-3 decision that is wrecking Hawaii's illegal Second Amendment prohibitions. The case, of course, is called Wolford versus Lopez, the Attorney General of Hawaii, fresh out of the oven, and the decision is brought to us, like many others that came out this very day, by the great Samuel Alito. He's being joined by John Roberts, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and in the dissents, we have Sotomayor, Kagan, and Jackson in a 6-3 ideological split. And so let's see what Alito had to say. He says, for years, the state of Hawaii made it almost impossible to obtain a license to carry a firearm. But 4 years ago, however, this court held in a very seminal case called Bruin that the Second and 14th Amendments protect the right to carry handguns outside the home for self-defense. Outside. Hawaii responded by replacing its old law on carry permits with new laws that carry a similar result. On a large portion of the land within the state's boundaries, possession of a firearm is now flatly prohibited. And the law now before us severely burdens the ability to actually carry a firearm in much of the rest of the state by prohibiting firearms on private property without the express and affirmative consent of the property owner. So Bruin says you can carry guns outside for personal protection, self-defense. They said you can only take it places on other private property if they actually approve it. If the bar or the restaurant or the library or whatever expressly approves it. So this law sharply departs from the standard common law rule on this and on access to private property open to the public. Under that rule, everyone, including those lawfully carrying firearms, may enter unless expressly prohibited from doing so. So the default is it's allowed unless it's not allowed. Unless the bar says this is a bar, there's alcohol, we're not going to allow you to do that. Hawaii inverted that. It's by default disallowed unless it's allowed. By contrast, under the new Hawaii law, no one carrying a firearm may enter without the property owner's express authorization. The effect of this new rule is to impose severe restrictions on the daily activities of residents who went through the very stringent requirements of getting a permit. When these permit holders leave home in the morning, they not only must they take care to avoid all the territory where gun is prohibited outright, but they also may be barred from entering many other places that people routinely visit in the course of their daily routines, like gas stations, convenience stores, restaurants, coffee shops, drugstores, grocery stores, big box homes, home improvement stores, barber shops, hair salons, everywhere. Hawaii hobbled the Second Amendment, the very right that is protected, the right of the American people to carry arms for self-defense as they go about their daily lives. And so therefore, we hold that Hawaii's gun law is unconstitutional. When Hawaii adopted the law before us, it did so against our prior decisions. And we therefore begin with a review of the body of the law. Second Amendment, as we know, beautiful one, says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We had other cases, Heller, which was a hallmark decision. Then we had Bruin, and we've talked about the fundamental right of self-defense. In light of this, it's not surprising that the Second Amendment was passed because of self-defense. And so because the Second Amendment protects rights that already existed, these are not new. The Second Amendment was adopted. You had these very same allowances. Heller instructed courts to ascertain the scope of the right. Heller emphatically rejected ahistorical balancing tests and all these other regulations we had around guns. And he gives us a lot of history on these gun cases. Chicago had gun laws. Then we had McDonald. Then in Bruin, we considered another decision of some other state that severely restricted the right of the handgun outside the home. And in doing so, we fleshed out the process. We said it's a two-step process. First, a court must determine, does the law clash with the plain text of the Second Amendment? Does it apply to the people? Does it apply to all members of the community? Does it concern an arm? Does it place restrictions on keeping or bearing those arms? If it does, then it's presumptively unconstitutional, which means it may violate the pre-existing right that the Second Amendment codified. But because that right was not in every way coterminous with the amendment's literal language, further analysis may be needed. A variety of sources and scholarship all came into this. There were a bunch of analogs about Bruin. And we're asking whether these can be analogized to current law. So applying this framework then, Bruin held that the New York law, which broadly prohibited law-abiding citizens from carrying commonly used firearms, violated the Constitution. The state's analogs as to why they needed to do this were very different than the challenged law. And the historical evidence was about self-defense. New York was infringing upon that. Then other states imposed it as well. And Hawaii was one of them. Now in Bruin, the law was about conduct, specifically about firearms outside the home. We see with this background, we turn to Hawaii. Before Bruin, Hawaii issued firearms carry licenses only in exceptional cases. In fact, wild. You live in Hawaii, from 2000 to 2018, only 4 licenses were issued. After Bruin, Hawaii and 4 of the other 5 states called out by our decision. They then flipped the private property rules. And a common law, if you open up your private property to the general public, that implies a license to all people to enter. No person is a trespasser merely by entering. And after Bruin, they then singled out all private property to make the default rule. You can't bring it in by default. The new rule is part of a tight web of laws that severely restricts the Second Amendment. To start, carrying a handgun for self-defense requires a special license. It's a rigorous process. Applicants must complete a detailed registration form. But even if you do get that, then there's 2 additional restrictions saying you can't bring it in anywhere. Stadiums, movie theaters, public libraries, and more. So you're prohibited and restricted from exercising your right. So what happened is 3 residents of Maui, they have concealed carry permits. They sued. District court said, you lose. Private property. Actually, the lower level court said you win. Panel of the Ninth Circuit reversed and issued a new matter. So we granted cert to determine whether Hawaii may prohibit a licensed concealed carry permit holder from carrying handguns on private property open to the public unless the property owner gives them express permission. So a lot of details here, and we'll just kind of fast forward through some of the law. To see what Hawaii's new default rule means in practice, consider a resident on Hawaii whose situation is like Jamie, a young Boston woman who wanted to carry a weapon to defend herself from a violent ex-boyfriend. But she was prosecuted when she used a non-lethal weapon to defend him off. Suppose our hypothetical young woman, after clearing all the hurdles, needed to get a Hawaiian carry permit, leaves her home, carries the gun in her purse. On the way to work, she fills up her car. During lunch, she plans to walk to a fast food restaurant and a drugstore. After work, she wants to pick up some clothes at the dry cleaner and shop for groceries. Unless each one of these says guns are welcome, she can't bring that in under Hawaii. And so when our hypothetical young woman visits the restaurant, her situation may be even more different. Unless her place of employment has a gun locker, she can't leave it behind. So lots of hypotheticals. And in some, the state says, we have a long history in Hawaii. So our history and tradition is we don't allow guns. Under 1833, King of Hawaii, King Kamehameha, right here, the third, Kamehameha, the third, the king of Hawaii out there. He said, we have banned these all over the place. But that argument is different than other arguments. We've already explained the Second Amendment has the same meaning in all parts of the United States. It cannot give way to the spirit of aloha in Hawaii. We don't care about King Kamehameha. We care about the Second Amendment. It applies in the same way to our 50th state as to our 49th state. Merely local attitudes can neither shrink the Bill of Rights or the protections of the 14th Amendment, which incorporates rights to the states. When we assess whether the challenged law is consistent, we seek a general understanding of the law that was codified at that point in time. And we now turn to their main argument that the colonial and early state laws support their rules. And their early laws, they say, were mostly laws that prohibited hunting of deer or small game. The earliest analog is a 1721 Pennsylvania law. Then we had a 1722 New Jersey law, which was about preventing the killing of deer. Then 1771 New Jersey, again, about deer and hunting. So in some, their analogs are about unauthorized hunting. Their coverage differed sharply from the Hawaii law before us, which is about preventing you having a firearm in private locations that are open to the public. So to test whether these analogs are relevantly similar, we ask a question. Is it actually similar? The question answers itself. The gap between the state's anti-poaching analogs and the new rule is just too wide. And their other analogs are even weaker. In 1893, Oregon prohibited people other than an officer from being armed. And on its face, it's not clear to us this is even relevant. Even if commercial establishments are open to the public were considered enclosed, no Oregon authority shows that Oregon, in their law, used the term to refer to such establishments. And then the most remarkable analog is an 1865 Louisiana law. We could stop there, but there's other reasons for rejecting their reliance on this law. It was adopted by Louisiana between the end of the Civil War and Reconstruction. When the war ended, legislatures in defeated states quickly enacted black codes that aimed to perpetuate subjugation of blacks. The statute that Hawaii cites was part of that. It provides a tool for disarming blacks. And they're like, well, that's good precedent for us. So as we laid out in McDonald, the right to keep and bear arms was crucially important to vulnerable blacks. And this was well understood by the Republicans of Congress, who were responsible for drafting and approving and securing the ratification of the 14th. Unless we put history entirely out of our minds, Hawaii's claim that this tainted artifact illuminates the original understanding of the right to keep and bear arms cannot be taken seriously. So you can't analogize this to some other laws and say we're allowed to ban this right. The Hawaii law at issue here violates the constitutional right to keep and bear arms. Therefore, the judgment of the Court of Appeals for the Ninth Circuit is hereby reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered, and it is so good. Thank you to Judge Alito. Now, Amy Coney Barrett came in. She says, I just want to add this in. This is why Hawaii also fails. They insist here, the principal dissenter, that this is a case about property law. They say, oh, it's private property. They can do what they want with their property, so the dissent's going to make it about property rights. The argument goes like this. No one has the right to enter private property, let alone bring firearms onto it without owner consent. Amy Coney Barrett. Whether consent can be implied or expressed is local custom. And so in Hawaii, if they want to make local custom the default that you can't bring it, they're allowed to do that. It's their property. By requiring express consent, Hawaii has simply modified the default rule of property law. And because the pre-existing right did not require any particular default rule, Hawaii's law does not even implicate the Second Amendment. They say no further analysis is necessary, according to Kitanji. This argument misunderstands the role of historical evidence in Second Amendment case law. We have to look at the history to illuminate the original scope of the right. Bruin's first step is easily satisfied. These are laws to the people who want to bear arms on property open to the public, and they make it a crime to do that. So it's irrelevant for the purposes of our amendment's plain text that they have a right to exclude people. No one doubts that they could bar this if they wanted to. But the Second Amendment does not apply to private parties. It applies to the states. So we're limiting what Hawaii is doing. And when a state enacts a property law that regulates the Second Amendment, that law implicates the Second Amendment. Consider how Hawaii in the principal dissent's argument would play out. What if a state made it a crime to wear a religious head garb, like, let's say, a hijab, onto private property open to the public without obtaining permission? Could that law evade constitutional scrutiny? If you believe Hawaii and Ketanji, the answer is yes. No one has a right to enter another person's property, and the state has merely adjusted the default rule to require permission. But that is wrong. Because the law regulates religious conduct, it triggers First Amendment scrutiny, and the state passing the law is the state endorsing that conduct. If you want to prevent some lady from coming in with a hijab, you can make that argument based on property rights. But it would implicate other areas if the law is being endorsed by the state. Same goes for the default rule like Hawaii. This targets the Second Amendment, and it was a pre-existing right. The Second Amendment didn't create it. It was already pre-existing. They just put it in the Bill of Rights to make sure that dictators stopped trying to attack it. Under Hawaii's new default rule, no licensed individual can carry a gun anywhere unless they have authorization. They say, well, in Hawaii, guns scare us or something. And so these attitudes appear to reflect the state's aloha spirit, as explained by the Supreme Court of Hawaii, saying, we don't want it here. But they still have to follow the laws of America since it's an American state, whether they like it or not. They got to go back to 18th century laws. They've got to identify analogs that allow these limitations on the Second Amendment. They've done a terrible job of that. They've cited a bunch of things like referencing poaching and uncultivated land and other things. But what is the regulatory principle here? Some might zero in on the fact that they targeted poaching and say it's similar, but that's too narrow. Legislatures targeted poaching during the colonial era to address particular misconduct, but they weren't self-defense rules. So this is a regulatory problem that is not poaching. 18th century hunting regulations don't support a rule. And Hawaii then goes to the 19th century. But again, they don't even dispute this, that it goes up to black people being disarmed. And I guess Ketanji is okay with that. Louisiana was one of the states. Alito addressed a lot of this. She's getting a little bit, I think, duplicative. But it is beyond me, writes Amy, why Hawaii would claim that these vile laws can justify present-day restriction. We can put aside the question of whether they are legitimate evidence of the Second Amendment scope, because regardless, they do not help Hawaii. The state seems to think that Bruin is a matching game. Like southern states enacted broad default rules, Hawaii reasons, so we can do the same. But even if Hawaii is right that the how is analogous, it must identify the why. The black codes were enacted to subordinate newly freed slaves. Hawaii obviously does not contend that its law promotes unanalogous interest, so its laws and the default rules in the black codes are not relevantly similar. Most would take that as a compliment. So applying old principles to new standards is not always easy. This case is not hard, however. While most Hawaiians might prefer that no one carry firearms in public, what is with them? What is that? A majority opposition to a constitutional right is not a permissible basis for restricting it. After all, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy and to place them beyond the reach of majorities and officials and a bunch of apparently firearm-phobic Hawaiians who don't want guns. So Kagan comes out, she drops her dissent, and of course, she would ban guns everywhere. She says, I respectfully dissent in a very short one. Here, there are other limitations that do properly analogize to historical tradition, and so she would ban it in that regard. Jackson and Sotomayor saying now Ketanji's a private property person. Yeah. So you get the point, saying if they want to ban it on private property, they can do it. So she also thinks she wants Bruen overturned. She doesn't want people to actually have a Second Amendment. And she said, Hawaii used to be a sovereign kingdom and they never allowed guns. Well, it's why they're no longer a sovereign kingdom. It's now why they're part of the United States. In 1833, King Kamehameha, he said no dangerous weapons. That's why they should have had guns. Maybe they'd still be Hawaii and not a state in America. So they lost, and it's a great decision for America. Another 6-3 victory in favor of the Second Amendment. Shall not be infringed. Do not impinge on our Second Amendment rights, even if you have the Aloha spirit. And get some guns down there. They're amazing. You'll enjoy them. Just go try it. Stop surfing for 2 minutes. Go just shoot one time. You'll be hooked. They're amazing. Great reason to be an American. So another amazing victory out of SCOTUS. We'll see what else they concoct to try to take away your right to defend yourself. Handed down by God, codified by the Bill of Rights, because they hate guns. They do not want free people. They want us all to be like living under the black codes. Even Ketanji doesn't quite get it. So we'll keep our eye on this one. Thanks for joining and subscribing as we do. All right, we got one final decision that dropped today. And let's take a look at this one. Very curious one. And this was 7-2, right? Yeah, very curious. Let's take a look. Very interesting decision from the Supreme Court in the Monsanto case. You know them as the makers of Roundup and other maybe cancer-causing chemicals that are spread all over our planet. This decision was 7-2, and it's not exactly split along ideological lines like many other 6-3 decisions are. In fact, there's an interesting pairing down here. As you'll note, the main majority decision was written by Kavanaugh. He's joined by Roberts. We've got Thomas, Alito, Sotomayor, Kagan, and Barrett all joining. What the heck? So we got Sotomayor, a lefty, and Kagan joining with Kavanaugh and Roberts and Clarence Thomas. Then Jackson is dissenting, as she's prone to do, and Neil Gorsuch is joining with Ketanji. It's like bizarro world here. Clarence Thomas with a concurrence. Let's see what's going on in this one. But Kavanaugh kicks it off. He says, look, under authority granted by federal law, it's called the Federal Insecticide, Fungicide, and Rodenticide Act. The EPA regulates all of these things, including pesticides and pesticide labels. So federal law says what goes on the bottle. Here, EPA regulates Roundup, glyphosate-based pesticide that Monsanto makes. Now, because the EPA has repeatedly concluded that glyphosate is not likely to cause cancer, the agency is not just like the EPA and the CDC and the CIA and the NSA and the FBI, just like they're really credible on everything. Okay. Has said, oh, no, doesn't cause cancer. Put it on your Wheaties in the morning. The agency says no cancer warning. So importantly, the EPA's regulations require a pesticide manufacturer like Monsanto to use the EPA-approved pesticide label here. Monsanto did that, and it does not have a cancer warning unless and until EPA says put on a different label. And so they want to ensure uniformity in labeling. We have the FIFRA, which is the governing act that is federal law. FIFRA governs all of this, and it prohibits states from imposing any other labeling requirement. So if your state says, oh, it's definitely causing cancer, I put it on my garden and I grew an extra limb, and you want to say we're going to issue warnings on this, they say no. So John Dernell brought a failure to warn tort suit in Missouri. This guy, John, sues Monsanto. He says, there's no warning of cancer. I've been using that for 30 years. Now I'm riddled with tumors. Dernell said they failed to warn him of this thing, and he literally did develop cancer, non-Hodgkin's lymphoma as a result. He says it is the Roundup. Who knows if causally it is or not, but that's what he says. But Dernell's state tort claim saying, I'm suing you for damages for getting cancer, that would require Monsanto to add a cancer warning, even though federal law says they don't have to. They only have to use the EPA-approved label. So because his tort claim would impose a pesticide labeling requirement, we hold from the court 7-2, the label required by the EPA is preempting his claim. So the federal rules beat the state rules or beat his claim that they need to add it. Here's where this goes back to 1947. Congress passed this. 1972, Nixon signed something else and transformed it into an EPA regulatory protocol. Under the scheme, pesticides must be registered. They go through an extensive review and they propose labeling. Manufacturers must also submit information about the formulas, and the government does a thorough review. 100% effective. 100% effective. You're not going to get any problems. 100%. Trust me. I'm Rachel Walensky. FIFRA authorizes the EPA to issue regulations to carry out the provisions. Putting all that together, before registering a pesticide, EPA must evaluate a pesticide and its label and what it does. It cannot be false or misleading. And so it cannot also omit unnecessary warning. Now, after they've registered the pesticide, the manufacturer must use the label. If they don't, they may be subject to penalties for failing to warn, criminal or civil, and misbranding problems. So all of this regulatory role doesn't just stop with labels. If they want to modify the label, they got to go through another process of registering. There's a slew of tools that they use to testify these things. And if they fall out of compliance, there are penalties. And so in addition, the EPA may cancel a registration if they're not in compliance, all the regulations. And finally, and crucially to this case, says Kavanaugh, this includes a preemption clause, all of these regs plus preemption, meaning they beat all other competing laws from the states. In a provision entitled uniformity, they adopted this. They said states are prohibited, cannot impose any requirements for labeling or packaging in addition to ours, and big chemical and big EPA sets the label. In 1974, Monsanto, a subsidiary of Bayer, creates Roundup that controls weeds. It's a glyphosate-based pesticide, and there is no cancer warning. In 1991, for more than 3 decades, EPA has repeatedly reevaluated glyphosate, repeatedly concluded it's not likely to cause cancer. For example, they classified it as unlikely to cause cancer in 91, 1993, same thing. Then in 17 and 19, the International Agency for Research classified, glyphosate as a probable carcinogen. So other agencies internationally say, yeah, it's probably causing cancer. EPA said, what? It is? Let us look. They re-examined and they said, no, it's not. Issued new rules. Then in 2020, they reiterated the same position. And so their assessment is shared by many other bodies around the world. It's not carcinogenic, according to Canada, Australia, Japan, European Union, and more. So all told, in accordance with this, with the view from the EPA, it's not likely to cause cancer, they don't have a warning. Therefore, as a matter of law, they legally must use a label without a cancer warning. So then in 19, John Dernell sued. He said, I've been using Roundup for 20 years, and I got cancer now, non-Hodgkin's. And he brought a failure to warn tort claim. A jury agreed, awarded him $1 million for not being properly warned about this. In trial court, they moved in on preemption. They say, you can't force us to warn you. Federal law says we got to use their label. They said, don't use a cancer label. Trial court rejected Monsanto's preemption argument. Court of Appeals affirmed that, said, nope, you're liable, should have warned. And so to resolve that split, we granted cert. And it's going to be a pretty straightforward, I think, decision here from the majority. Preemption means preemption. Uniformity is in the law. Court precedents make clear that state torts constitute labeling requirements. That makes good sense. After all, the heart of his claim is that Missouri tort law that allowed this claim to go forward should have included a cancer warning. that would have required a label on the Roundup bottles. But the EPA says they are legally required to use it. It's true the EPA may subsequently change that and then amend it and say, oh, actually it does cause cancer. Or it's only 99% effective or 97% effective or 95%. Oh, and you need a booster every 6 months because, okay, and so on. So in some, federal law requires Monsanto to use the label, and federal law preempts. And so the state law can't beat them. Gives us some other examples. In a Bates court, there was a relevant labeling problem. Here, EPA was about danger warnings, and there were other failure to state a claim there in prior cases. Same thing with the Regal case, but that's not dispositive here. In short, under federal law, Monsanto was required to get approval. They did. They put the label that they were put on there. His failure to warn claim is expressly preempted by federal law. He makes other arguments saying that this requirement under state law is a little bit different, but that's implausible. By the text, it's explicit. And it contravenes other arguments, and referencing regulations under the EPA is all incorrect. And the dissent is seizing on this miscellaneous provision in the law where it says, in no event shall registration be construed as a defense. He says registration could not serve as a defense to some other action, but that argument erases the express preemption clause. So this one preemption defeats all of the other claims that you can lodge under this type of a failure to warn problem. And it's all problematic. And so, not surprisingly, the US government represented at oral argument the EPA does not bring a misbranding action when the manufacturer was using an approved label. If you're using our label, we're not going to come after you for using our label as the government. So long story short, all of his other arguments fail. Any other citations are all going to be preempted. And more examples from third parties. If they want to bring new information, we're sorry you got cancer, but it's not from this, but if you think it was, you're free to bring new information to the EPA, and then they can modify their labels and update their registration. But otherwise, you're preempted. You don't get to sue. We reverse the Court of Appeals from Missouri and remand this case down for further proceedings not inconsistent with this opinion. So the guy's going to lose on the way back down, and he has cancer too. So that just sucks for that guy. And I've got my doubts about a lot of these, government assurances of safety because they lied to us about not doing gain of function research. Oh no, we're not doing anything funky that's going to damage you. Then they did, then they lied about it, then they sold another damaging thing and then lied about that. And they're still lying about it. No one's going to jail for it. So we're a little skeptical here. But the law is the law, right? You got to operate within the confines of the rules. So I agree with the court's interpretation, says Thomas, that this is preemption. But I write separately because there are other unconstitutional infirmities with the act. So the act as it stands dictates this outcome, but that act might be unconstitutional in general. And here we go again. It's a Commerce Clause problem. You congressional jerks. Article 1, Section 8, Clause 3 says Congress only has authority to regulate commerce among the several states. Commerce Clause jurisprudence has been perverted throughout the history of America to mean that commerce means virtually everything, like literally everything. If you make a widget and you sell it in your state, you're not even trying to go across state lines or be a national widget maker. If your widget changes the market of widgets because people are buying from you in your state, that means they're not buying the guy in the next state over his widget. So now you are in interstate commerce. What? I didn't even leave. Sold it to my neighbor. I'm selling milk to my neighbor. Well, your milk's going to end up in the intranational market. So we're not going to allow you to do that. Now we can regulate your milk production for your neighbors. He says This power allows Congress to regulate selling, buying, and bartering across state lines. It does not allow Congress to regulate agriculture, manufacturing, and activities entirely separate from commerce, which they do. The act is a comprehensive regulatory statute that appears to regulate more than the Commerce Clause allows. And so, among other things, it requires manufacturers to register with the EPA. And if they don't use an approved label, they're liable to damages unless it's from the state. And it raises questions about their ability to delegate legislative power to the EPA. Then Congress creates an agency, then the EPA passes their own rules and is essentially acting like an independent Congress. And it also raises questions about preemption. The Supremacy Clause says the Constitution and the laws are the supreme of the land. And administrative action appears difficult to fit under the Supremacy Clause. So how can EPA regulations be supreme to state when they're not a legislative enforcement by Congress? Laws that are made by Congress and the president are the ones that are supreme, not some independent agency's garbage. But the difficulty illustrates the consequences of the modern administrative state and our now mistaken separation of powers jurisprudence. If agencies were not exercising core legislative power, especially through schemes that exceed even Congress's power, there would be far less occasion to address conflicts between agency actions and state law that the actual constitutional framers would not have envisioned. And so Thomas would basically say the entire EPA, essentially, is a violation of the Constitution. So, but I'll agree that we're not going to go with that holding. That's not the question before the court right now. But these rules and these acts are outside of the power of the courts. And so at some point we should come back down and say the Supremacy Clause doesn't apply to agency actions. It applies to Congress and to the president, the laws signed into place by president. Otherwise, we shouldn't even be allowing these types of things to happen. So Ketanji came out and she's joined by Gorsuch, which is interesting. And let's see what their argument is. They say, well, before we've rejected preemption. In my view, the majority should have joined the chorus. His failure to warn claim is not in addition or different from other mandates. It's equivalent to misbranding. So it's not actually trying to override federal law. It's in parallel. So I dissent in accepting Monsanto's argument and holding the failure to warn claim is preempted. The court is misunderstanding the preemption claim, misinterprets the scope of the preemption, and leaves him without a remedy. The dude has cancer. And he had $1 million judgment, and now he's not going to get any of it. So that preemption doesn't box out all state regulation. The state can still require certain things to happen. And she goes on for quite a bit here, along with Gorsuch. And critically here, the EPA's regulations do not set specific requirements for label warnings related to chronic risks like cancer. So they're only warning as to certain things. There's only certain labels they can put on there. The state, in other words, is filling a gap that is not prohibited or precluded by the federal law. Federal law is big and broad and leave some holes. The state is filling the holes. So the preemption only applies to the things that are articulated, not the holes that are being filled by the state. The state can easily slot in there and make a claim. And that's what they did in Missouri. And this dude has cancer. And so Ketanji, joined by Gorsuch, goes through all the text and says that's exactly what they did. The EPA is not infallible. It's true. Yeah, or the CDC or any of the other agencies. But in sum, this guy loses. Any other state attempts to force labeling look like they're going to fail as this rule is laid down. And he's basically done. Let's see how she closes it out. Having rejected this, I conclude that by addressing its alternative contention that the failure to warn claim is preempted Monsanto argues it's impossible to comply with both labeling requirements. It's not. All they could do is stop selling in Missouri or make a different label. In any event, their implied preemption argument fails. And here, they don't need special permission. They could just update their labels in Missouri. And while a cancer warning may not seem like a minor modification, facts on the ground belie that. On at least 6 occasions, the EPA has permitted manufacturers to add state-specific warnings as minor modifications. Among the manufacturers that have previously added cancer warnings are subsidiaries of Monsanto. And so this unjustifiably closes courthouse doors to state torts like Dernell and these big mega chemical companies are shielded from certain legal claims, 7-2. And I understand the decision, but it does feel like they get away with a lot of things without much recourse. And so they say no cancer, just like they said 100% effective. So take that for what it's worth, but that's the decision, 7-2, majority holding. We'll see if they update those labels anytime soon and whether it is confirmed that they do cause cancer. But for the time being, this man, Dernell, loses his claim, and we'll see if anything else emerges from this one. Thanks for joining and subscribing as we do. All right, friends. That was 4 new Supreme Court cases. If you're just getting here, we had some really good ones today. 6-3 on Homeland Security. TPS status is not subject to judicial review for procedural and conclusion review by unelected federal judges. The stay and the pause on TPS cancellations by the Trump administration is now canceled and denied. Sent back down, which means the Haitians and the Syrians are hopefully packing their bags. We also saw, what does it mean to arrive in the United States versus at the United States? In Mullen versus Al Otro Lado, Sotomayor with a very upset dissent on this. If you come to the United States, you're not allowed to say that you're in the United States and then get all of the benefits of asylum and refugee status and have to be processed. You just get turned away. Go back home. Sorry if you made the long journey. Shouldn't have been incentivized to do that in the first place. Supreme Court saying the statute means what it means. In means in, and that's the end of the story. Then we had a big Second Amendment win. Wolford versus Lopez out of Hawaii. Hawaii tried to infringe on everyone's Second Amendment rights by reversing the default rule that you can bring firearms outside of your home for purposes of self-defense, even if you go into private property locations that are open to the public. Hawaii inverted that and said you are by default not allowed unless you get explicit permission. Supreme Court said that that makes no sense at all. Another 6-3 and the Second Amendment. And then we had the last one, Monsanto. Monsanto Chemical Company now cannot be sued under a state court tort theory for a mislabeling and causing cancer, according to one dude named Dernell. 7-2. And so that case is mostly dead, and that immunity will continue on. So 3 really good ones for sure. We also heard from the Supreme Court SCOTUS blog that they'll be back on Monday, 10 a.m. for more decisions. We'll be here to go through them all. So thank you for joining and subscribing as we do, because we're getting closer and closer. We had, what do we have? 12 today. So that means 12 at the start of the day. We had 4. So that means we've got 8 left. Pretty sure probably should get a calculator for that, but 8 left. And so some big ones that will be coming out later. And yep, we're looking forward to it. And friends, thank you for sending in these donos and for being here. Let's see what you say about all of this and more. It's a beautiful day. And let's check out your comments. Hey, Gina sent this one yesterday. They sent them in from other countries to defraud American taxpayers. Yeah, and I just can't believe how ungrateful they are. They come in, we give them everything. Then it's time to go home. They say, no, I have all of the constitutional rights that an average citizen does, and you can't deport me, and I'm going to sue you. And you're going to have to expend millions and billions of dollars trying to get us out. It's like, why would we even bring you in the first place then? Yeah, anchor babies, man. Anchor babies everywhere. And they leave them here for like 16 years, 25 years. Meanwhile, they're just dropping babies all over the place, which makes it harder to remove the original people you brought in. Ridiculous. G-Men, yeah, we read that last week. He basically did the same thing today, G-Men, in the Monsanto case. Commerce Clause, you can't pass these things. You can't regulate this activity. The whole structure is illegitimate. We love Clarence Thomas. He's the man. Hey, biology always wins. What's going on? Bringing in some friends. Miko Star. What's up, Miko Star? Welcome. We got Possible Dreams in the house. Marty Foker. Good to see you. Effie and CED Keon, all gifted memberships, courtesy of Biology Always Wins. Thank you, Biology, for bringing in our new membo friends. Very nice to have you. We got Mo Sheg. A lot of the 6-3 are common sense rulings. Yeah, and they're just looking at the law, like arriving in the United States. Pretty simple. What does determination mean? Well, it means it's like a math equation, like, oh, it's like 50-50. No, it means determine. It's the process of making a determination. But they have to contort themselves. This is the problem if you're not a textualist or an originalist. You have to contort yourself into getting the outcome that you want, which is why they make it up like a living, breathing constitution. And they go and they invent a right of abortion out of the Constitution. Oh, it's from a penumbra of other rights. Can you like articulate? No, it's from a mystical penumbra. And it just emerges. Like, okay. Like emerges like a baby? No. We want to kill them. Okay, got it. So, hey, Wojo, funny how when there is a 6-3 decision, I can usually guess who the three are. Yeah, it's a pretty safe bet. It's a pretty safe bet. We'll see on Birthright. We'll see if that causes an interesting split. But we'll see. Coming back on Monday for that one. Thank you, Wojo, for the dono. Hopefully your Thursday's amazing. Hey, Go Ho Shane says, FYI, Rob, it's pronounced Monsanto. Monsanto. What did I say? Monsanto? Monsanto. They have successfully sued farmers for open-air pollination of corn. Farmers have lost the entire crop yields to them, claiming patent infringement. I've seen that, yeah. Like, I don't have a lot of love for Monsanto. Because it feels like I've also remember when they were coming up, they had like a very incestuous relationship with a lot of people, right? Weren't a lot of people like ex-Monsanto executives who are also in like the Department of Agriculture or these EPAs? It's like kind of this little bit too close for comfort on that. I think they patent the genetically modified crops so that if you get a seed, like a seed is patented, you can't use their seed, right? You use their seed, they sue you. That's our gene. Can't use that. So farmers then become beholden to them, and you got to get like a resubscription of all their seeds, which are apparently very good seeds, you know, or in other words, they're genetically modified, but they're resistant to crops and all the, you know, to fungi and bugs and all the other things. Thank you, Go Ho Shane. Monsanto. Thank you for the heads up. Zone Girl, hey, I love that he leaves a foundation and roadmap to get our Constitution back. Thomas doing so much work to lay a foundation. Yeah, and it's great how he also like doesn't miss an opportunity. Like he could just say, I'm not going to write a concurrence. He's like, I have to write a concurrence to explain why the Commerce Clause is perverted. Like, thank you. You didn't have to say that. It's not even before the court, but he just makes a point. Excuse me, we're not ending this until I make my Commerce Clause argument. Like, we love you. Thank you. Mike Alvord, Rob, you do a great service going over the SCOTUS decisions. If only the buffoons on the left would look at the reasoning before reacting. Yeah, and what's interesting about this is we don't even get to see the reaction. Like, we spent, you know, the last 3 hours here actually going through the mechanics. Then I get off and I see how everybody's interpreting the cases. And I'm like, we just read it. I didn't see that in there. Like Trump's killing black people, black Haitians or something. You're like, what? Did you read it? You clearly didn't. Thank you, Mike Alvord. We appreciate that. Mock Schnell, I wonder if the Monsanto decision will affect the Prop 63 warning labels here in California as they beat us to death with warning labels on everything we buy. Yeah, I've noticed that. California, everywhere you go, this will cause cancer. This will cause cancer for your babies. You're like, I'm getting a Coca-Cola. Cancer, cancer, cancer. It's everywhere. And then if everything is cancerous, then is like nothing cancerous. It's really kind of a death by warning labels. Are there cancerous materials in all the warning labels and all the sticky glue? Thank you, Mock Schnell. Good to see you. Do you think if birthright cases don't drop on Monday, it's an indication that the leftists are slow walking their opinion again? So the arguments were later in the term, so it might just be a sequence of that. I also think like if we get a bunch of good rulings on immigration, which we did, we got 2 good immigration cases today, then that may, speculating, not bode well on that decision. So in other words, they'll say like you can keep people out, you can kick them out with TPS, you can kick them out at the border, keep them out if they come for asylum. But if they're in here and they drop a baby, then maybe that's like the trade-off. But yeah, like they really delayed out, I think it was the Roe versus Wade decision, right? Like they really delayed that one out. So they are tactical about it, but I got to think it's written already. So I don't know. I'm not sure that timing really matters too much at this point. It's like, now it's just a matter of days, like 4 days, or maybe it comes back on Tuesday. But if it's the leftists that are holding it up, then that means it's going to be a good decision for us. And I'm not sure it's going to be a good decision for us based on Gorsuch's questioning in there. I think Amy Coney Barrett, some of her questions were like, oh gosh, this is not good. So we'll see. I'm still hanging up hope. Maybe they could just invalidate the executive order on some other mechanism and not actually get to the constitutional underpinning of the amendment, or hang it on residency versus subject to the jurisdiction thereof, or punt it in some other way. But we're going to find out soon enough. Thank you, John Thomas. Good to see you. Hey, Dark Servient, great to see you. Thank you, Dark Servient, for becoming a membo. We'll see you on the next membo stream. Wojo, so if a foreigner has a baby in my house while visiting the U.S., does that make them a part of my family? Well, I think if you ask Sonia Sotomayor, yeah. Doesn't even have to be in your house, just at your house, and it's yours. So you get a Haitian who comes and plops a baby on your front lawn. Congratulations, you're a grandfather. Yeah, so that's, I think, her interpretation. Hey, Rose Blight, what's going on? New subscriber for 5 minutes. Been watching for a while. Thanks for keeping us up on this information. Thank you, Rose. Thank you for subscribing. I know many people are not subscribed, and it breaks my heart into 1,000 pieces. Causes deep, deep pain. So thank you for subscribing. Rose, we appreciate that. DARPA's too busy training foreign nationals in country how to, quote, fix our country. Yeah. DARPA and the ACLU too, probably. We got a lot of them. And they're not really interested in America. Thank you, Don, for the dono and for being a membo. Hey, BNS Systems, what's up? Thank you for being a membo. 3 for 3 on both immigration and the Hawaii Second Amendment case is huge. Great day. Yeah, it's a great day. Which, makes me nervous because like then we're going to have our heart broken. Wow, we're so in love. We love you. Everything's amazing. Except this. So I hope I'm wrong. And we're going to stay positive. We're going to will it into existence. If it's bad out there now, they're going to flip at the last moment. Hey, weekends in Vegas, libs, weirdo, law interpret equals many U.S.'s problems. Yeah, that's right, because they don't actually govern by principles. They literally believe in a living, breathing constitution. They just think that they're like another legislative branch and they can find ways to impose their political ideology through the law. And the text doesn't really matter. You look at legislative history. You look at international norms. Well, how are other countries doing this? We don't care. It's in the law. Thank you, Weekend in Vegas. We got Psychological Projectionist says neither American nor non-American are races. No. And the fact that Haitians happen to be, a large number of a certain ethnicity doesn't make criticism of Haiti or Haitians racist unless they're the real racist and they just think all black people are Haitian or something. And we're allowed, as a country that is not suicidal recently, before that we were, to have preferences for immigration without being called a racist. Some people are more in alignment with American values. Some people come here and they don't leech off the social safety net system as much as others do. Some people actually care about the values that we care about. Some people aren't going to come in here and scream at us about living on stolen land. Sean of Time, first it's time. Oh, sorry about that. Sean of Time in the house. What is thyme? Is that like something you cook with? Second, bro, you need more than a swear jar with that language. Uh-oh. Well, I was just reading what the Supreme Court wrote in their decision. Are you thinking my mother should come over here and wash my mouth out with soap like she used to threaten when I was 9? Russell Smith, hey, baby names, boy, justice, if a girl, liberty. Those are pretty good. Justice is kind of feminine though, right? What if it was named like Gavel or Supreme Gouveia? Really the one that I think we're getting close to settling on is Harambe, Agamemnon, Genghis, Gouveia. Harambe, Genghis, Agamemnon, Gouveia. So we're getting close on. Thank you, Russell, though, for the suggestions. Very good. Hey, the Savage, my penance for being 2 hours late and for reading us Thomas's concurrence. He's the only voice of reason to Sotomayor's pure lunacy. Yeah, thank you, the Savage. Thank you for the nice dono. Glad you're here. Glad you made it for this. Good ones today. Very good ones. We'll have some more on Monday. Yep. And thanks again, the Savage. We got, hey, psychological projectionist. Does the doorstep have a border that has a doorstep? And you're asking about being in or at the doorstep. Yeah, it's very complicated. So as long as you're in the doorstep, then you're in America, according to Sotomayor. Hey, can tell you never watched Dragon Ball Z. Think of Goku when pronouncing the Samoan king. King Kamehameha. Kamehameha. Kumehameha. King Kumehameha. All right. Well, it's called Hawaii now, a.k.a. America. Nice. Thank you, voice of the people. Hey, the Savage, EPA is corrupt. If they were over tobacco, they'd say, nope, doesn't cause cancer. No need to warn customers, ridiculously overlooking the obvious. Yeah, which is, largely how many of these entities are, including the CDC, including the NIAID, National Institutes of Health. Weird. You're an institute of health. How come you're causing a global pandemic? Doesn't make any sense. And then when you find out about it, they lie to you. So yeah, I'm not too trusting of them. Hey, in Winning Reality, is the SCOTUS not aware of birth tourism? We have to end birthright citizenship. It's been gamed. You're right about that, Winning Reality. They are aware of it. It came up during oral arguments. I think, pretty sure D. John Sauer brought it up and said, almost 90% sure. I think he said like 1 million birth tourists. Didn't he come up with that number? Like 1 million people may be birth tourists. They come over, drop them off. They have clinics literally set up for this. Hey, Jamie's on Brummel. Hey, my son's name is Justice. It's a good one. Is it? Yeah, I don't know why I thought that. So it's more masculine. Justice. It's a good name. We've got a couple names that are picked out and they're different. They're different. So you might like it or you might hate it depending on what happens, but we like them and we think that they're good. So we've got a couple picked out. And if we can't really decide on them, it's going to be Harambe, Agamemnon, Genghis, or maybe Genghis, Harambe. The sequencing is very important. Friends, thank you for those amazing donos. We appreciate you sending those in and supporting us on the day. It has been a good one with some very nice decisions. Let's see. We got a couple of other comments. G-Men. Yeah, says he argues that just because a gun crossed state lines when it was manufactured and sold does not give the federal government police powers over the end user who owns the gun under interstate commerce, from G-Men. Yeah, Clarence Thomas is the man. Yeah. We love Clarence. Zone Girl, I love that he leaves a foundation and roadmap to get our Constitution back. And good to see you, Zone Girl. And Bonnie, what's up, Bonnie? I can see it now. By their argument, someone could be charged with trespassing if they are on the other side of a property line or outside the building. Yeah, because they're in the building when they're in the next zip code, because they don't know about spatial awareness or how to interpret very simple prepositions. Rubos, Yauman's job, Rob. Thank you so much. You're the best at what you do. Everyone pales in comparison. Well, that's a really nice compliment, Rubos. I don't know about that. Own it. Humbly, of course. LOL, we love you. We love you back, Rubos. RubosSaltShop.com. The only salt we use in our household, because it comes from the oceans of France. We love it. Good to see you, Rubos. Is that how I say it? Yauman? Don't even know how to say it. That's how terrible this is. Hey, what's going on over here? Commie Mom Donnie just opened up the floodgates of defund the police, abolish ICE, free Palestine, tax the rich, sanctuary cities, and anti-Israel. Oh, yeah. That got unleashed a couple of days ago. Wild times. Hey, what's up? Couple other comments here. Liberty or death. Yeah, unfortunately, I'm worried what you're saying is correct. Deal in time to save Birthright. SCOTUS calendar now shows Monday as well. Hopefully, Sotomayor is holding on to her dissent again. You know, Thomas will have something to say either way. Can't wait to read that goat's thoughts on it. Yeah, we'll see. I hope they do the right thing for America, man. I really do. Chuck, I don't know if the Monsanto ruling affects organs, but they are not organs, but they are trying to pass a law that you can't use insecticide or rodent control poison here. Interesting. Chuck saying, yeah, Grok says it might have some impact on that. Insecticide or rodent control poison here. So are they going to grow anything? Humble Satellite Board. Gorsuch gave Ketanji a pity join. He's such a nice guy that he saw her being the odd one out time after time and decided to join her dissent to boost her self-esteem. He's like, oh, I'll go eat lunch with her. Fine. Turbo, Rob, isn't the SCOTUS TPS decision dispositive? Isn't dismissal with prejudice the only path forward for the lower court? I think it was a remand, wasn't it? To like basically reapply the standard, reversed and remanded. So yeah, reversed on their decision, but I'm wondering if they can go back, because I think that, I mean, we could have been reading it wrong, but I think that they left open because, like, just add it up here. Alito with the main holding, judgment of the court, deliver the holding, except as to Part 3A. So Roberts, Thomas, and Kavanaugh. So we got Alito 1, we got Roberts in full, deliver the opinion of the court except as to Part 3A. So, like, I'm not sure if Part 3A is part of the decision. So Alito, Roberts, Thomas, and Kavanaugh. So that's 4. And then we've got Gorsuch and Barrett joined except for Part 3A. Okay, so Gorsuch and Barrett are over here. So the and Part 3A, as we looked it up, was equal protection. So they joined in the TPS analysis, but not the equal protection claim. So for the equal protection claim, that was really a 4, right? So that's just Alito, Roberts, Thomas, and Kavanaugh. Gorsuch and Barrett joined except as to the equal protection claim. So while Alito said that would fail, he doesn't have a full majority on that. Is I think how we're reading that right now. So if you're down there, I think you might exploit that. You might say, well, you know, as to 3A, which is the equal protection claim, that doesn't have a full majority. It's Alito, Roberts, Thomas, Kavanaugh. And then Gorsuch and Barrett joined except for Part 3A. Thomas with the concurrence, but he's already in the 4. So yeah, it's a little bit convoluted. But I think if I'm down there, that's the argument I'm going to make. It's good to see you, Turbo. I don't like them hanging on to the most anticipated decisions until the last day. It makes it seem like they're thinking about more than just the cases themselves. Yeah, like maybe they're trying to time it or something to comport with the politics. Here's somebody jacked into the phone. He may be the next influencer or my intern or both. It's natural selection, addiction, explicit material, predators, bullying, and data privacy. Interesting images here. Democrat Party turning into the Communist Marxist Party. That's true. AZ Soccer Opa. If Birthright case was in our favor, the left on the court would have leaked it already. Another good comment. Yeah, maybe that's true. And this one from Rick D. You just can't laugh hard enough. She's going to crash the banking system by taking out her $37 on July 4th over some video from Rick D, which
it's time for
we'll take a look at. I'm not sure exactly what this is. Oh, she's encouraging a bank run. She's calling for a July 4th bank run, and this is what she looks like. All right. Okay. She's going to cause the collapse of America. Thank you, Rick D. All right. So, friends, let us pause here on the day. Your boy got an invite to go join Jesse Kelly. And so I think that's happening relatively soon. Yes, 2:15, Jesse Kelly, your boy got an invite. And we're going to talk about these cases today. So that's going to be fun. All right, so we'll pause here on that. We'll be at Jesse Kelly's house in about 1 hour from now. And that should be fun. I think after that, I think we'll probably come back and do another stream this afternoon. I don't know what the heck's been going on out there. Sometimes these days are just all about, SCOTUS stuff, but I presume there will be some other good stuff to cover. And then we'll come back. We'll do another show at our regular time and have some fun doing that. But once again, thanks for being here. Thanks for joining us for these very important days. I know I learned some things. I hope you did too. And we appreciate your conversation, your friendship, your fun, the great comments, the support. Thank you for subscribing and all the things. We'll pause here for a few short hours. Go check out Jesse Kelly. If you want to check out what we're talking about, we'll do a very compressed conversation about this today. And then we'll come back later this evening and see what else the day has in store that is not SCOTUS related. But if you're only here for the SCOTUS stuff, make sure you're coming back on Monday and probably a couple other days next week once those get scheduled, because we got still 8 more cases to get through. Not sure we're going to get all of those done on Monday. So we may have 2 more of these days, and these are important times. So we'll be back. It's a beautiful Thursday. I hope that you are out there getting after it, accomplishing all the things you set your mind to. Big thank yous to our amazing mods and meme smiths who keep things nice and orderly for us. We got Donut, Mind Me, K Bean in the house. Thank you for clipping. And of course, Carrie B also clipping for us. We got John, Neuro, D, Janik, Dog Digger, Geegum Geegum, Elliot, Just Rhonda, and all of our amazing friends here. We love our amazing mods. And once again, thank you, friends, for being here. It's been a beautiful stream, but we'll pause here. We'll hit the outro today on a double outro whammy in celebration of our tremendous victories. We'll come back in a few short hours. And until we do that, be well and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay.